Delivery of judgment item 24 and 25 from supplementary list.
For reasons mentioned in the judgment, both the impugn orders are set aside and quashed, and these three civil revision petitions are allowed.
May I please, Your Lordship? Your Lordship, I have filed an arbitration appeal. There's some urgency because it's a Section 8 application. May I pray that it may be listed tomorrow?
Roster.
Your Lordship has all appeals are listed before Your Lordship, including arbitration appeal.
What is the urgency?
Your Lordship, my Section 8 application has been rejected and the learned court below has fixed the matter for hearing. No reasonable opportunity is also given for me to file a written statement. And if I have to file a written statement, this appeal will become frustrating. Because after I filed a written statement, I'm basically subjecting.
Okay.
Wait,
No.
wait, please, Your Lordship.
That's-
I beg to mention for listing of two MFAs, Lordship. One is MFA 38 of 2013 and another is 2 of 2016. Lordship, these two appeals were of 2013 and 16, Lordship. And the issue involved in this appeal is already dealt by this Honorable Court, Lordship. So my humble prayer is kindly this matter may be listed in the month of March, that is on 10th of March,
Or for what?
for hearing, Your Honor.
We'll fix it for orders first in the next week. Then it will go for hearing. Next week. or-
Next week, any date, Lordship?
No date. Next week.
Obliged.
No, give a date.
Twenty
24th.
Wait, please, Your Lordship, with regard to item number 22 and 23, my lord, I am appearing on behalf of respondent number 2 into item number 23. I have some difficulty today. It has come for hearing. May I pray for listing of this matter in the next week at any
You have
date?
informed the other side.
We are appearing.
For the appellant, madam.
I am for the claimant, my lord. I have some urgency, my lord, because the amount has already been deposited. And I have filed a miscase, but that was understanding that hearing will be taken up.
When we can take it up?
Any day
On
next week.
24th or
Well, can it be 26, madam? 24 some difficult, 26,
26th,
next Friday, Thursday, madam.
26th.
26 Paribu. First week of March.
Yes,
Date the
date
specific.
may be-
5th March.
5th of March.
I am obliged.
What is your name?
Well, A. Roy. I
On
am
requ-
appearing item number 23 for respondent number 2.
On request of in item number 22,
I am for the claimant.
item number 23. On request of Mr. A. Roy, learned counsel for respondent number 2. No, the learned counsel for respondent number 2 has prayed for an adjournment on the ground of personal difficulty. Though Mr. M. Datta,
MK Mishra.
M.K. Mishra, learned
For respondent number 1, madam.
counsel for the claimant respondent had objected to the prayer. No. However, considering the submissions made by learned counsel for respondent number 2, the prayer is allowed. Show also presence of Mr. M. Datta, learned counsel for appellant. Let this matter be listed on 5th of March
I am duly obliged.
Diploma.
For hearing.
for hearing.
May it please the Lordship, I beg to mention an item for listing under the orders column, my lord. The matter was last listed on,
What is the matter?
that is an MSc appeal, my lord. It was-
MAC appeal.
Yes, my lord. It was last listed on 17/5/2024, my lord. Almost in 2 years have passed, my lord, the matter is not listed. That can be listed under orders
When?
column. My lord. Any date to the.
Next week at the date. 25th.
Oblige, my lord.
My please, Your Lordship, I beg to mention for listing of MSc appeal for order has the matter has been settled outside the court. Your Lordship may kindly fix the matter on 22.
Okay.
May I please your lordship? Lordship, I beg to mention for RFA appeal on 19th. This is an urgent matter. Lordship may kindly list the matter in the admission column.
Twenty.
Authorized.
May it please your lordship. Lordship, I beg to mention for listing of an IA in the MAC appeal, lordship. IA for condonation of delay, lordship, notices have been served.
When?
Lordship, on Monday or Tuesday.
Tuesday.
Deeply obliged, lordship.
May I please, your lordship, I beg to mention item number 15. Lordship, in this case, we were directed to take pre-steps by way of paper publication. And to this effect, we have also filed an affidavit, but the same is not on record. So can it kindly come after it's on record, lordship?
We'll ask the registry to place the affidavit on record. You have submitted your affidavit
Yesterday.
Saxon, bring the affidavit on record. We'll see if it comes, we'll take it up. Otherwise, we'll adjourn it.
May I please?
Obliged.
Lordship, I pray for listing to MAC appeal for orders follow. Any date next week?
26th.
I'm so obliged.
Bail hearing BA, item 11.
No, item number 1 mato. Okay. No, we can take up bail. This referral matter will not take much time. Item number 1. 1 to 10.
Number 1 to 7.
May it please your lordship. Your lordship, these cases are not fit for mediation, your lordship. We are denying liability in all the cases, your lordship. We pray that it may be heard finally in a hearing, your lordship.
Heard Ms. P. Thakur, learned counsel for the appellant. Also heard Ms. What is your name?
J. Akhtar.
Ms. J. Akhtar.
Hello, I am appearing for respondent number 7 and 8, man, driver owner.
And Mr.
DK Das.
B.K. Das, appearing for respondent number 7 and 8. And Mr. What is your name? B. Das, appearing for respondent. Appearing for APDCL. Learned counsel for the appellant submits that why it is not fit for mediation.
Lordship, we are denying liability in all the cases, your lordship. This is not on quanta.
Learned counsel for the appellant submits that since the appellant is denying, he is taken a plea in all these appeals regarding denial of their liability to compensate the respondents. Hence, she submits that this is not a fit case to be referred to mediation and it required an adjudication by court after hearing. Learned counsel for respondents also agrees to the same. Hence, this court is of the view that the aforesaid appeals are not fit to be referred for mediation. Accordingly, list the same for hearing after 4 weeks on a date to be fixed by registry.
Lordship.
Same order. Common order, same, one order only.
Item 8 and 9.
Lordship, these cases cannot go for mediation.
Why?
Lordship, because the ground we have seen in this, the father cannot be considered as a dependent. One of the ground is there. And the case is already in the hearing stage, Lordship.
Heard Mr. S.P. Sharma, learned counsel for the appellant. None has appeared for respondent. Learned counsel for the appellant has submitted. What is your name?
I approach.
I?
I hope.
Also heard Mr. IHOP, learned counsel for the respondent. Learned counsel, what is your submission?
Lordship, if matter may be referred, I have nothing to say.
No, Lordship, we cannot.
Though learned counsel for the respondent has no objection in referring the matter to the mediation. However, learned counsel for the appellant submits that since the appellant has raised a question of law and same needs to be adjudicated by the court, it is not a fit case to be referred to mediation. Stop considering the submissions made by learned counsel for the appellant as well as after going through the materials on record. This court is of considered opinion that this is not a fit case to be referred to mediation. Hence, list the same for hearing.
The 10th of March, Lordship, if possible.
Data Tadyam. On 26th March.
Deeply obliged.
Highly appeals.
Item 10,
So we filed this appeal for quantum. So it can be settled in the.
Lordship cannot be settled as because I approached the insurance company, they offered a meager amount. Awarded amount 34 lakhs with interest. They offered 20 lakhs only in total.
No, this can be discussed again in mediation.
This matter has been fixed today for hearing. In fact, there is order.
It's fixed for mediation, Your Lordship.
No, Lordship, it may not be possible. Let it be listed for hearing.
Okay, the service is complete and it can be fixed for hearing.
Hearing, Lordship.
If there is an.
Heard Mr.
Yes, sure.
S. Sharma, learned counsel for the appellant. Also heard Mr. M. Talukdar, learned counsel for the respondent slash claimant. Though the learned counsel for the appellant submits that this matter may be referred to mediation. However, the respondent is opposed to referring the said matter to mediation. He submits that on an earlier instance, when the respondent approached the insurance company, the effort of conciliation failed,
Lordship.
and therefore he submits that no result would yield in the mediation. Considering the submissions made by learned counsel, he also submits that otherwise this matter is already ready for hearing. Considering the submissions made by learned counsel, this court is of considered opinion that this is not a fit case to be referred to mediation. List the matter for hearing on 7 early.
Early, Lordship.
March.
If possible, they will.
When?
The month of March.
March
24th March.
24th.
It will be
Before
Before that.
March, first part,
In fact, 2 days fixed for hearing.
10th of March.
10th of March.
No, Lordship. Earlier or one,
Lordship, it
2
would be,
days.
inconvenient.
Two
for
fixed
senior.
matters there on 10th, Lordship. 5th of March, Lordship.
5th of March. 5th of March.
Lordship. Grateful.
Bail hearing be item 11.
Sorry, time being lost. SRSR is coming close. Sorry, time being lost. I mean,
Item 12.
12, Lordship, there is an office note, 9/2/26, whereby Lordship, it is stated that TCR has not been received, and the notice upon respondent number 2 also, Lordship, is yet to be received.
This is a POXO matter.
Yes.
so Madam Lordship, only the Lordship is the petitioner, accused petitioner, him is more aged about 75 years, and his condition is deteriorating in the jail. He's suffering from multiple ailments.
Heard Mr. H. Agarwal, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. On perusal of the office note dated 9/2/2026, It appears that the scanned copy of the trial court record as well as scanned copy of the case diary have not yet been received. Stop. Issue reminder for the same. It also appears that no service report in respect of notice issued to respondent number 2 has been received. London. Additional public prosecutor is requested to inquire about the fate of the notice issued to respondent number 2 from the officer in charge of the jurisdictional police station and let this court know about the same on the next date fix. Let this matter be listed. 11th of March, shorter date, 6th of March.
Item 13.
13 Lordship, he is on interim Lordship and he has appeared. And Lordship, there is a note of the IO which states Lordship that
Lordship,
he was served.
may I please, Lordship, senior is coming.
Not
Kindly pass
necessary.
the matter for timing, Lordship.
Mhm.
Is late
Lordship,
sentence.
the IO has served 35 notice also to him, Lordship, and he was not arrested also.
What is the name?
Yehuda.
Heard Mr. Yehuda, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that the petitioner, who is already on interim bail, has appeared before the investigating officer, and the investigating officer has also issued notice under section 35 within bracket 3 of BNSS. No requirement of arrest.
That Lordship, I will not say.
Okay.
Materials are there, Lordship, that may be reclaimed with this.
He, however, submits that there are incriminating materials against the petitioner on record. So, in the case diary, instead of on record in the case diary. I have considered the submissions made by learned counsel for the parties and have gone through the case diary. Since the petitioner has complied with the directions of this court and has cooperated with the investigation, the interim bail granted to him by this court on 8/9/2025 is hereby made absolute with condition number 1 and 2 attached to the said order remaining intact. This anticipatory bail application is accordingly disposed of.
So he will appear as and when called for, that is there.
That condition is there.
Item 14.
14 Lordship, they are on interim. I am praying for some time to update the CD Lordship. It will be required, Lordship.
You have appeared or not?
Well, appeared. Several times.
Whether
Last chance Lordship for updation and.
no. Why have they appeared or not?
Lordship, that I am trying to find Lordship. I could not find it, Lordship. Because Lordship, on the earlier occasion, their anticipatory bail was rejected on the ground that they have issued some threat to the victim. Thereafter, Lordship, of the second bail application, they were granted interim again. So that part, Lordship, I just have to verify.
Okay. Let them verify. We'll extend the interim till next day. Heard Mr. B. Sinha.
N. Burua.
Sorry. Heard Mr. N. Burua, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though the petitioner is on interim bail, however, the case diary which is available before the court is not up to date, and he prays for some time for updating the case diary. The prayer is allowed. Let this matter be listed on
9th of March.
9th of March. The interim bail granted earlier shall continue till next day.
Item 15.
We'll fix it on some other day. Heard, Mr. What is your name?
My name is B.B. Kakoti.
B.
B.B. Kakoti.
Heard, Mr. B.B. Kakoti, learned counsel for the applicant who submits that the applicant has taken steps for issuance of notice on which respondent?
On the sole respondent.
On the sole respondent by substituted mode of paper publication. He also submits that the applicant has also filed the affidavit in compliance thereto. However, said affidavit is not tagged with the case record. So in view of above, the registry is directed to place the affidavit filed by the applicant with the case record on the next date fixed. Let this matter be listed on 5th of March.
Of last year.
Hearing item 16.
My lord, matter will come up after 1 week. My lord. I have some personal difficulty today and also the opposite party is,
You have informed.
no, my lord, I have not.
Had Mr. P.J. Fukon, learned counsel for the appellant. None has appeared for the respondent. Learned counsel for the appellant has prayed for an adjournment on the ground of personal difficulty. Stop. Considering the submissions of learned counsel for the appellant, the prayer is allowed. Let this matter be listed on 10th of March.
Most of.
Item 17.
Appellant is not there.
Because the last time you lost see the outer sick matter. Last time, my lord, the judge thought that has been given. It's a very long pending matter, 15 revision, my lord. MF. Always, my lord.
What is to be done?
My lord. It will be for default, let them come, my lord. In that case, the matters will be heard on the day when they appear.
We'll fix it on day after tomorrow. If they fail, we'll dismiss it. None
I
appears,
think so, I always, my lord.
none appear for the appellant on call. Mr. G. N. Sahavela, learned senior counsel, assisted by Miss M. Devi. M. Das, learned counsel for the respondent, is present. Learned counsel for the learned senior counsel for the respondent has submitted that on last occasion also, when the case was listed for hearing, no one had appeared for appellant. Hence, he prays for dismissing this appeal for default. Stop. It appears from record that on 8/1/2026, when the matter was listed, on that day also, none had appeared for appellant. However, the court is inclined to give one more chance to the appellant side. Hence, let this matter be listed on 19th of February for hearing.
Item 18.
Yes.
Malad, this is Malad against order of the Lanet RCT, Malad, Railway Claims Tribunal, Malad. Malad, imposition of Malad, punitive sides on overloading, Malad. Malad, one prayer, Malad, one Malad officer from the railway, Malad, he is waiting outside, Malad, for assisting me, Malad. If you not kindly allow me, Malad, he'll just assist me, Malad, in this matter, Malad.
Okay. And so what is your prayer?
That appeal may be dismissed, my lord. They are
No, no.
Yes, my lord.
Not on that. Now, what is your prayer immediately?
Malad, he is waiting outside. If your lordship kindly allows him to come inside and assist me, my lord. That is only prayer, my lord. Some Malad technical things are there, my lord.
Okay.
So he'll help me, my lord. In this regard, my lord. That's some
Okay.
calculations, my lord.
We'll take it up as next item. Next item, we'll take it up. You
Malad.
can take assistance of anybody.
Deeply, my lord.
19.
Lordship, pass over for the time being.
Why?
My senior is engaged 14 member.
We'll wait now.
Okay. Okay.
Item 20,
Your Lordship may kindly fix the matter at 2 p.m.
Why?
My senior is not here. She will come, Miss R. Chaudhary.
Okay. Okay, at 2.
Okay, obliged, Lordship.
Other side 9, huh? Eating Matakson.
and we got an 18.
Yes.
My lord, this is my lord, against my lord, the order dated. This is the order dated 24/11/2016 passed by the Railway Claims Tribunal, my lord.
Where is the order?
My lord, the order is at page, my lord. Page 10, my lord. Page 10, my lord. My lord, this is a common order, my lord, starts from page 11, my lord.
Yes.
My lord, regarding my lord 46 OA, my lord. Now, my lord, we are concerned with my lord. Serial number 37, my lord. At page 12, my lord, serial number 37. Page 12.
OM number 479.
Yes, my lord. 479 of 07, my lord.
OA.
Sri Mahalakshmi Mills. My lord. Now is, my lord.
What was the judgment?
This judgment, my lord,
Why the original applications were filed?
my lord, some consignment was booked, my lord, to be transferred through railway wagons, my lord. And my lord, they were loaded on the wagons. But my lord, where the wagons were loaded, my lord, there is no way bridge, my lord. Lordship, my lord, the way bridge, my lord, where, my lord, the wagons are weighted, my lord. My lord, the wagons, the way bridge placed on the, my lord, the railway line, my lord. And my lord, the whole train goes up to the way bridge, my lord. And when this a particular my lord, wagon placed over that way bridge, my lord, the weight of the consignment is measured, my lord.
Okay. Yes.
And my lord, if it and the original, we know the original weight of the wagon. If we deduct the original weight of the wagon from, then my lord, the weight of the consignment, we can measure the weight of the consignment. Now, my lord, there are, my lord, every wagon, my lord, there are several kinds of wagon, my lord, but there is a carrying capacity of the wagon, my lord. Of
Yes.
each wagon, my lord. And my lord, and the consignment, consignor is
supposed to supposed to load the wagons up to that limit only. And my lord, they declared the weight. And on the basis of this, that declared weight, my lord,
Who declared?
my lord, the consignor.
Okay.
We are the railway the consignee.
Whether he's told beforehand that this is the maximum capacity
Yes, my lord.
of the weight which
Yes,
you,
my lord.
okay.
And my lord, he then declared. Then one RR, railway receipt is issued, my lord.
Yes.
And on the basis of that RR, my lord, the weight of the all wagons, we calculate the value of those consignment as per the distance to be covered by the that rack, my lord. Several wagons consist of a rack.
Okay.
So, my lord, but where the consignment were booked, my lord, there is no facility of, my lord, measurement facility, my lord. So what happened, my lord? It was weighted on way, my lord. Where, my lord, that facility was available, my lord. And, my lord, we found that
On way means on from the in between the original station to the destination.
Station, my lord.
Okay.
We waited, my lord, on the wave list, my lord.
Yes.
Then, my lord, we found that there are more weight than what is declared, my lord. Carrying capacity, my lord.
Yes.
And more than the carrying capacity. Now, my lord, there is a provision, my lord, in the Railway Act, section 73, my lord. If we found that there is overweight, my lord, then the carrying capacity.
No, you can find out how much excess weight this
Yes, my lord, carrying. Now, my lord.
Shri Mahalakshmi means
Yes, carrying.
load was carrying.
So, my lord, we found, my lord, I will show it from the documents, my lord, along with the, my lord, trial court record, my lord. The documents are also there, my lord. How much, my lord, overweight found in each wagon, my lord.
Okay.
I'll show it from the documents, my lord, later, my lord. It is, my lord, in the LCR, my lord.
Yes.
Now, my lord, as per section 733 of the Railway Act, my lord, if I can read it, my lord. My lord, it is, my lord, section 73 is, my lord, punitive charge for overloading a wagon.
Yes.
My lord, may I read, my lord? Where a person loads goods in a wagon beyond its permissible carrying capacity as exhibited under subsection 2 or subsection 3 of or notified under subsection 4 of section 72, a railway administration may, in addition to freight and other charges, recover from the consignor, the consignee, or the endorsee, as the case may be, charged by way of penalty as at such rate as may be prescribed before the delivery of the goods, provided that it shall be lawful for the railway administration to unload the goods loaded beyond the carrying capacity of the wagon if detected at the forwarding station or at any place before the destination station, and to recover the cost of such unloading and any such charge for detention of any wagon on this account. So, my lord, on way, my lord, on over, my lord, wave when, my lord, we discovered, my lord, overweight, my lord, we have, my lord, offloaded those things, my lord. And, my lord, we have.
In this case, have you offloaded the excess?
Yes, my lord. My lord, in this case, my lord, we have allowed them to carry, my lord, this way, but punitive charge was imposed, my lord.
Okay. Thereafter, what happened?
My lord, now, my lord, what have now the question is, my lord, that now we have to, my lord, impose punitive charge on the, my lord, the excess goods, my lord. My lord, we where at the destination station, my lord, the punitive charge as well as the weight of the my lord, extra consignment, my lord, loaded, my lord, where my lord were charged, my lord, and also, my lord, for detention of the wagon, my lord. My lord, that is detained for detention. My lord, there are some extra time given. My lord, when the wagons reach in the destination station, there are some free time given to the consignor to offload the goods, my lord. But if they could not, my lord, they could not, my lord, offload those goods, my lord, then, my lord, some extra charges are imposed. And, my lord, that is called, my lord, demurrage charge, my lord. Demurrage charge, my lord. And that was also imposed, my lord. Now, in this,
What happened in this case?
my lord, I'll come to, my lord, lordship may kindly come to page number 39, my lord. One minute, now, man, if your lordship, my lord, the calculation is given, my lord. Freight charge distance from TLT to NGC 157.
Your OA number is?
My lord, OA number is 479, my lord. Last one, my lord, 37.
Okay.
37, my lord.
Yes. What is TLD?
Tilda, it is the station, my lord, that is the originating station, my lord.
What is the name?
Just a minute, my lord. I'll give the RRS here. My lord, these are abbreviation, my lord.
No, but
I should give the name, my lord.
what is
That
the,
is why, my lord, taking assistance from my.
what is the meaning of TLD?
My lords, tilde neura.
Tilda like that.
Railway station.
Tilda?
Neura, Neora, tilde, TILDA, Neora.
Where it is? In which state?
My lord, I'll just find it, my lord. I'll first find it out.
Jaipur district.
Rajasthan.
Yes. Chhattisgarh, my lord. District is showing Jaipur, but Chhattisgarh is showing that.
And where is, what is NGC?
New Gauhati, my lord.
New Gauhati, my lord.
Okay. Yes.
My lord, the distance is, my lord, as per our calculation is, my lord, 1570. 1570. Tariff rate is, my lord, 109 per quintal.
Yes.
My lord, total, there is 3,760 quintal rice book at the rate of 109, my lord. The amount is 4,11,570.
Yes.
Now, my lord, the next page is freight paid 4,17,000, my lord. Next page, my lord, page 40, my lord.
Yes.
My lord, C, my lord, at C, B is freight paid, C, my lord, under charge paid at the destination station is 31,733, my lord. That is the, my lord, punitive charge, my lord. And, my lord, demurrage, my lord, charges paid at destination station is 20,000. My lord, demurrage charge, my lord, once again, my lord, I mentioned, my lord, the extra time they have taken for
Offloading.
Offloading, my lord. And, my lord, total is 469. Now, as per their calculation, it should have been 411, 4,11,570. So, my lord, total freight overcharge is 57.962. My lord, that is their claim, my lord, that the railway should refine that that amount to the consignor because we have taken it illegally.
Claim was allowed.
Claim was allowed, my lord.
Have you refunded it back?
Not refunded it, my lord.
Till now, you have not
Not
refunded.
refunded it.
Okay.
My lord, that is the whole case, my lord. Now, my lord, there is a decision of this honorable court against this section 79. As per the section 73, my lord, of the Railway Act, it is mandated that the railway can take punitive charge on overloading, my lord. Once they find it, my lord, the overcharge is detected, overweight is detected, my lord. Now, my lord, they have challenged this provision, my lord, this section, and my lord, a full bench of this honorable court decided, my lord, against the railway, my lord, deciding that without providing a opportunity of hearing, you cannot put charges, my lord. Thereafter, my lord.
Opportunity of hearing means before imposing the charges,
My lord.
other side has.
Principle of natural justice. Yes, my lord.
Otherwise, the charges can be, punitive charges can be imposed.
Yes, my lord.
Okay.
And demerits also, my lord, I'll show from the, if you, my lord, I'll show the demerits, my lord. Definition of demerits, my lord. It is, my lord, Act, my lord, Railway Act, Section 1, Section 2, subsection 11, my lord. Sections 2, subsection 11, my lord. Demerits means the charge levied for detention of any rolling stock after expiry of free time, if any, allowed for such detention.
And where is the provision that you can impose such charge? It is the definition. Where is the substantive provision where demerit can be imposed?
My lord, there are circulars, my lord, master circulars, my lord.
But in Act, it is not there.
Not there.
It must be there somewhere, because when demerit is defined,
My lord.
there must be somewhere provision to impose.
My lord, it is
Under
there.
what provision demerit is imposed?
Just assist.
Now, my lord,
Okay.
my lord, now what happened, my lord? As per this, my lord, now, my lord, that was the judgment given by this honorable court was challenged before the honorable Supreme Court, my lord. And the, my lord, honorable Supreme Court, my lord, recently, my lord, overruled that judgment, my lord. It is on, my lord, May 20th, 2025, my lord. This is the judgment, my lord. And said that we can impose charges, my lord.
Without affording opportunity. Which para?
I'll show, my lord. Madam, para 11, lordship, may kindly. Madam, para from 9, from para 9, my lord, page 3. Page 3, para 9.
Please read.
My lord, page 3, para 9, my lord. We have considered the rival submission of the and carefully perused the material placed on the record. It seems to us that the principle evolved by this court through paragraph 42 of the cited decision, my lord, broadly addressed to issue of a challenge to the demand of panel freight for excess weightage. This court has held that such demand cannot be termed as the violative of Article 14 of the Constitution. In every nature of things, on rising such demand when excess weightage has been detected at the time of offloading, it would be practically difficult, if not impossible, for the appellant related to issue so-cause notice to the consignor or the consignee and to hold a mini trial to determine the question of excess weightage and consequent levy of compensatory charges. Nevertheless, the appellant railway need to update and upgrade themselves with this advanced technology. There is no gainsay that the mechanism like automatic videography of the loaded weight along with weight measurement at the time of offloading can save the parties from easily avoidable litigation. in the event any consignor or consignee dispute the liability towards the charges for excess weight, such electronically collected proof can be supplied to redress the grievances. We are quite sure that by now the railway must have introduced some effective scientific method to meet such challenges. However, what we have observed about is only on an illustrative basis, and to sensitize the railways. We hope and trust that with a view to insensitivity its consumer and customers, the railway will continue to upgrade regularly. As the science has gone far ahead and given the passage of time, we find that the impute judgment is now obsolete and redundant. The same is accordingly set aside. The appeal is disposed of on the light of the observation made herein.
It says that there is practical difficulty in issuing show cause.
Malad, it is also said that Malad, it is not violative of Article 14 of the Constitution, Malad. Section Malad 73, Malad.
No. That is with regard to some other judgment where
Yes,
say
madam.
that
Yes,
imposition of
Yes.
is
madam.
not violative.
So, Malad, in a way, Malad, the imposition of Malad.
Now, what the tribunal held?
Now I'll come to the Malad judgment of the tribunal, Malad.
Relevant portion start at page number 27, observation.
There are 15, Malad. Malad, issue 3. It is relevant to Malad, para 15, Malad, issue number 3, Malad. It is relevant to mention that despite direction given by this tribunal to the respondent to produce documents sought for by the applicants, in
Para 15 is at which page?
Malad 26 or 27, probably 26, probably.
26, okay.
Yes, Malad.
Okay, yes. What is the issue number 3?
Malad. Come to the issue first, Malad.
In regard to overloading. In regard to overloading, my lord.
Go to the issues first. Malad, issues as at page 20, Malad. Page 20, Malad. Para 5.
Whether the applicant is entitled to refund of the freight over charges as claimed. Okay, yes, please read.
It is relevant to para 15, my lord, I am reading. It is relevant to mention that despite direction given by the tribunal to the respondent to produce the documents sought for by the applicants, in its prayer for discovery of document, that is original forwarding note, loading tally book, unloading tally, delivery deficiency message, details of disposal of so-called excess weight or bags, full delivery record of so-called excess bags or weight, weighment chart, weighbridge, fitness certificate issued by the authority of the Department of Weight and Measures, legal methodology of the relevant period, and so-cause notice served to the applicants before imposing penal freight on allegation of overloading, correct chargeable distance, and rate from booking station to destination station. The respondent only produced copy of the document mentioned at para 4 above. The documents which we have produced, it is mentioned in para 4, In all the way, the applicant stated that the consignment were booked and loaded in railway wagon in safe, sound, and secured condition under railway rate. After complying the legal and statutory inspection as per railway rules. In OA so-and-so, a government-approved surveyor surveyed and witnessed the loading to verify the number of packages and their weight and recorded their finding in their survey report. But at the destination station, the official of the respondent railway demanded payment of penal freight, number 1, undercharge, demurrage. Charges on allegation of overloading detected en route. On the request of the applicant, the railway official verified and witnessed the unloading and recorded his finding in the railway unloading Telibo. At destination station, no excess goods were found and delivered. On the contrary, shortage were found. The applicant paid the penal freight under such demurrage charges under protest. Further, the collection of penal freight on allegation of overloading and that too without giving the applicant any so-cause notice is also violative of principle of national justice. Para 17. Whereas according to the respondent, when the consignment were reweighted en route, overloading were detected and accordingly penal freight under such demurrage charge was realized from the applicants. To substantiate their claim, the respondent filed weighman charge only in 10 OS, that is so and so, so and so.
Whether your OA is included.
No, my lord. I've checked. It's not.
Though in 45 OS, the respondent claimed that there was overloading. Besides, to prove that the weight bridge was in order, the respondent filed a weight bridge verification certificate only in OA number 88 of 16 and so and so and so and so. Details of the weight bridge verification certificate shown as under. My lord, this is the my OA is not here, my lord, in this table, my lord. The above weight verification certificate only proved that the concerned weights were verified on 30/9/2004, 12/8/2005 to 25/9/2006 and found fit for women. Simply issuance of certificate of verification for 1 year does not mean that the weights will become defective till the validity of the said certificate. My lord, thing is this, my lord, they have, my lord, what the tribunal has observed that though you are given a validity certificate for 1 year, that does not prove that it was the women was fit for the whole 1 year.
No, but in your case, that certificate
was not there.
not given.
When certificate is not there?
Payment chart as well, my lord.
Women chart has been given.
Not given. The payment chart, which was supposed to be conducted, which was supposedly conducted.
Oh, sir. Perusal of delivery certificate, para 19.
No, and weighbridge verification certificate.
Nothing, my lord. Not even
Okay.
verification certificate, not the chart.
My lord,
The result of the
my
chart
lord,
which indicates
I'll come
overloading.
to that also, my lord, regarding placement of documents, my lord. My lord, I'll clarify that also, my lord. As per my lord, railway circular, my lord, and my lord, which was upheld by this honorable court also, my lord, we are supposed to maintain the records of the, my lord, of the particular wagons for 6 months only, my lord. Because, my lord, thousands of organs, my lord, we cannot, my lord, preserve all those documents beyond 6 months, my lord. It is not possible, my lord. So, my lord, the provision is there that you are supposed to keep that those documents for 6 months only, my lord. And my lord, I'll show from the record, my lord, this all my lord questions come after my lord 6 months. And my lord, I'll show from the my lord judgment of this honorable court, which has upheld that my lord provision.
You can keep electronic records.
My lord,
Anyway.
my lord, yes, my lord, that may be, my lord. But my lord, what my lord, this honorable court has held in a separate judgment, my lord, that beyond 6 months, the railway is not required to, my lord, to keep those documents, my lord. That is, my lord.
Okay.
Perusal of delivery certificate filed by the applicant show that less quantity of consignment were delivered at the destination by the respondent to the applicants. That indicates that there was no overloading. Moreover, despite giving direction by this tribunal, the respondent also did not produce the detail of offloaded excess weight and its disposal. It was the respondent who contended that there was overloading. Therefore, it was for them to prove the same. But the respondent did not lead any concrete evidence to show that there was overloading. My lord, here, my lord, there is a provision in this, my lord, Railway Act, my lord. The, my lord, burden of proof lies on whom, my lord? The burden of proof, my lord, as per this, my lord, I'll go to the section, my lord. It is probably 105. Huh?
73.
My lord. My lord, Lordship, may kindly, my lord, so the exact provision in the Railway Act, my lord, section 110, my lord, burden of proof, my lord.
Yes.
110, burden of proof. In an application before the claims tribunal for compensation for loss, destruction, damage, deterioration, and non-delivery of any goods, the burden of providing the monetary loss actually sustained, where the value has been declared under subsection 2 of section 103 in respect of any consignment, that the value so declared is its true value, shall lie on person claiming compensation, but subject to other provisions contained in this act. It shall not be necessary for him to prove how the loss, the destruction, damage, deterioration, or non-delivery was caused. Now, my lord,
How this is relevant?
my lord,
Because you are imposing punitive charges,
My lord.
saying that it was overloaded.
my lord,
And at the destination, the wagons were found
my lord.
less than the weight which was there at the the station where it was loaded. So the burden is on you to
Uh,
show the excess weight.
No, my lord, these are my lord, my lord, this coal, my lord, we do not measure it, my lord, because it is not possible for railway to measure, my lord. They, my lord, but directly those goods are loaded from truck to wagon, and they give a declaration, my lord. My lord, if we come to, my lord, the document. my
No,
lord,
the tribunal held that the weight which was loaded in the original station and when it was weighed at the destination,
my lord.
it was found less than the original weight.
My lord, it was not weighted, my lord. It is their claim, my lord. My lord, for that, my lord, waivers is required, my lord. How can they, my lord, weight it at the destination station, my lord?
Then on what basis this
My
was?
lord, as I saw, my lord, the weighment was done between a place, my lord, before that, between the concept where, my lord, the loaded this, it is loaded, and destination station, my lord. So, my lord, at my lord, New Gauhati, my lord, there is no weighment facility. No, no.
Then on what basis delivery certificates are given? Because in delivery certificates, weights are mentioned.
Now, my lord, I'll show for
The tribunal says that
my lord.
the weight mentioned in the delivery certificate was less than what was it in the original station.
My lord, actually, I am also confused, my lord, how, my lord, the Honorable Tribunal has come to that conclusion, my lord, without weighting that weighment in the, my lord, delivery point, my lord. My lord, for that, coming to that conclusion, my lord.
Who gives delivery certificate? Railway.
Railway, my lord.
So in that, a weight is mentioned at the time of delivery. What was the weight of the?
Now that is the, my lord, crux, my lord. My lord, in the, my lord, RR, my lord, when they have booked, my lord, railway receipt, they have given the underweight, the less weight they have given, and which were we subsequently found in the weight list, my lord. So, my lord, in the RR, my lord, the original weight is there. So we have delivered them the weight which they have booked as per their RR, my lord.
Now, why you have not included the excess weight which you found?
My lord, now the excess weight, my lord, from the document, my lord. So I will show, my lord, in each wagon how much, my lord, we have received, my lord. That is in the document, my lord. LCR, my lord, I'll show.
No. First, you point out where the tribunal was has erred, where it was wrong.
The LCR, my lord, in the LCR, my lord, there is a document, my lord, where, my lord, when, my lord, it is, payment was done in the way bridge, my lord, on the way bridge, my lord. My lord, what we have found, my lord, the LCR, delay my ever declared, my lord. What could you do?
No, what is your contention?
Now, my lord, we have proved the fact that they are were overruled, my lord. And my lord, we have produced the document, my lord.
Which document?
My lord, I'm sure.
That has not been considered by the tribunal.
Yes, my lord.
But tribunal says that you have not adduced any, you have not laid any concrete evidence.
Just a minute, my lord. I'll just. Malad, we have produced one document which is missing from this, as per my record, my lord. Malad, I want to show it from my record, my lord. Malad, if it is not produced, then my lord, we cannot show, my lord. But still, my lord, I would like to show, my lord, from this, from my record, my lord, I am showing, my lord. Women's heart, my lord.
What is this?
My lord, this is the wagons, my lord. Around 40.
No,
wagons are there, my
what
lord.
this document is?
Women's heart, my lord.
Women chart.
Yes, my lord. Women's heart.
Yes.
And my lord, those were the wagons, my lord. Around 43 wagons are there, my lord.
Have you exhibited this document before?
My lord, as per my information, they have exhibited, my lord, but I could not find
But
it.
record would reveal.
Yes, record will reveal.
Yes, my lord, I think in the judgment, it has also been mentioned that no document has been produced by the builder. In the list of documents. of
Okay,
the
you have a copy of this?
I'm totally unaware, my lord. That's why I also submitted that payment chart was unavailable.
Yes, what you want? You have exhibited it.
My lord, as per my, lord, they have, my lord, the railway has provided these documents that we have exhibited these documents. My lord.
As exhibit what?
Yeah. But if it is not there, my lord, I cannot take help of this document, my lord. To be honest, my lord.
Okay. What this women chart shows?
Women's are showed, my lord. There are 41 wagons, my lord. Here are, my lord, 41 wagons, my lord, shown in this chart, my lord. And my lord, precisely, my lord, in what, which wagon, my lord? My lord, I have tallied it with the wagons also, my lord. And my lord, the RRs are there, my lord. RR, my lord, means, my lord, the railway receipt, my lord, by which they have loaded those consignment on the wagons, my lord. And exactly, my lord, against those my lord, wagons, my lord, there are, my lord, 6 my lord, RRs are there in this present case, my lord. And my lord, I have found, my lord, against those 6 RRs, my lord. That means, my lord, in those 6 wagons, my lord, how much overweight we have detected, my lord. And my lord, total amount, my lord, recovered from them is, my lord. It need add to amount to 2,42,700. So million. And my lord, 2,42,720 rupees was, my lord, charged, my lord, on the whole rack, my lord. But here, my lord, we are concerned with 5 or 6 wagons only, my lord. There are, my lord, around 30 cases, my lord, which are pending, my lord, lying with me, my lord, along with this case, my lord. So my lordship, may I pray, my lord, that this whole series may be taken together, my lord, so that, my lord.
Not like that. You have to defend each case.
No, my lord, I can at least, my lord, probably, my lord, so that, my lord, an uniform decision can be taken.
No,
my lord.
this submission you could have made at the very beginning, not now.
Yes. Mal.
Each appeal should stand on its own merit.
Mal.
What is your submission? Till now, apart from narrating fact,
My lord.
your one submission is that you have produced the payment chart,
My lord.
which you failed to show
from the record, my lord.
So that payment chart could not have been relied, and the tribunal came to the finding that you failed to adduce any concrete evidence to show that there was overweight. Apart from this payment chart, what is the other material which would indicate that?
Now, my lord, the RRs, my lord.
Yes.
Railway receipt, my lord.
Where are the errors?
6 RRs, my lord.
In the original record?
Yes, original record, my lord, it is there, my lord.
Yes.
My lord, last 2 pages in the records.
Page number?
But these numbers are not been recorded.
Which document you want to indicate?
My lord, I like to show, my lord, section 7 of, my lord, Railway Claims Tribunal Act 1987, my lord. My lord, I have mentioned, my lord, this consignment are mentioned as per the declaration made by the consignment. And, my lord, this type of consignment are called, my lord, in railway language, my lord, said to contain, my lord. Whatever they have declared, my lord, we accepted it. And, my lord, RRs were, my lord, railway receipts were, my lord, issued as per the declaration made by the consignor, my lord. Now, my lord, I want to show, my lord, while filing, my lord, a case, my lord, what documents should accompany, my lord, to produce their, my lord, to prove their claims, my lord. It is given, my lord, at section 7 of the Railway Claims Tribunal Act 1987, my lord.
Section 7 is term of office.
No, my lord.
My lord, Railway Claims Tribunal Procedure Rules.
My lord, procedure
Rules.
Yes, my lord. Page 17 of the Bear Act, my lord.
Right.
Procedure Rules.
The Railway Claims Tribunal Procedure Rule 1989, my lord.
Yes.
Section 7, my lord.
Rule 7.
Rule 7, my lord. Every application for compensation in respect of loss, destruction, damage, deterioration, or non-delivery of animals or goods, or in respect of refund of fare or freight shall be accompanied by the following document, namely,
yes,
copy of the railway receipt, parcel way bill, luggage ticket, original sale invoice. My lord, I am concerned with this, my lord. This is called Bizuk, my lord. Now, my lord, to note something, my lord, they have purchased some goods from somebody. And they have to prove that fact, my lord, they have to produce that much amount of goods they have purchased, my lord. And to, my lord, to prove that fact, my lord, they have to produce this bizu, my lord. So, my lord, I'm trying to say that they have also not made, produced any document to prove the fact that they have actually loaded this much of the goods on the wagon. What they have done, my lord, lordship, if we come to that, I'll come to this later, the RR, my lord, it is later recorded that it is said to contain no railway staff was there loading not supervised by railway staff, my lord. It is written on the RR. So, my lord, when loading was done, my lord, that was not supervised by the railway staff. Number one, my lord. So, my lord, we are not aware what is the weight of that thing, my lord. And second thing, my lord, they have not produced the bizuk also to prove the fact that they have purchased this much amount and they have brought it to the my lord loading yard, my lord. Now, what they have done, since it is said to contain, my lord, they have declared a weight, my lord, which we have recorded in the RR, my lord.
Okay.
Now, my lord, I'll come to section 65 of Railway Act, my lord. My lord, this is regarding section, my lord, railway receipt, my lord. Section 65, my lord.
Yes.
Section 65, railway receipt. A railway administration shall, in case where the goods are to be loaded by a person entrusting such goods on the completion of such loading, or in any other case, on the acceptance of goods by it, issue a railway receipt in such form as may be specified by the central government. Subsection 2. A railway receipt shall be prima facie evidence of weight and the number of packages stated therein, provided that in the case of consignment in wagon load or train load, and the weight of or number of the package is not checked by a railway servant authority in this behalf, and the statement to that effect is recorded in such railway receipt by him, the burden of proving the weight, or as the case may be, the number of packages stand therein shall lie on the consignor. So, my lord, as per section 65 also, it is the burden of the consignor to prove the fact, my lord. So, my lord, my responsibility is that, my lord, we have, my lord, found that there is overweight, my lord. And we have when weight, it is weighted, my lord. And, my lord, as per those finding, my lord, we have, my lord, as per section 73, my lord, the punity charge was imposed and that was realized, my lord. And, my lord, what the railway has done, it is as per the rule, my lord, and the burden lies on them, my lord. They have not adduced any evidence whatsoever that they have, my lord, what amount quantity they have, my lord, loaded on the wagons, my lord. And burden lies on them, my lord. Since, my lord, the Honorable Supreme Court also, my lord, upheld this section 73, my lord, that without giving, my lord, that, my lord, what, my lord, this Honorable Court has hold, my lord, regarding principle of following of principle of natural justice, my lord. Now, my lord, my respectful submission is that, my lord, railway has imposed the punitive charge, my lord, lawfully, my lord. And, my lord, so, my lord, my appeal may be allowed, my lord.
Yes.
May it please your lordship.
Putul.
My lord, before going into the merits of the matter, there's this one judgment of the honorable court.
Ronga column. Yes. Ronga.
Yes,
Yes.
My lord, before going deeply into the merits of the matter, my lord, there is this honorable court, our coordinate bench honorable court judgment, exactly in this angle, my lord, recently been passed, my lord. Interpreting section 73, my lord. My lord, my learned senior friend has already read the impugned judgment. That's why I'll straight away move ahead with my submissions, my lord. At para 9, if your lordship is there, my lord.
There are 9 of this judgment.
Yes, my lord.
Yes.
It is, the judgment is interpreting section 73, my lord. From the materials on record, if your lordship is there, my lord.
Just a minute. Yes.
From the materials on record, this court could not find any document which would suggest that there was an overloading by the applicant, which the appellant herein ought to have proved before the learned tribunal. My lord, herein the appellant is also Union of India. That means the onus of proof is upon the railway. Secondly, my lord, be that as it may, this court had put a specific query upon the learned counsel for the railways as to how the appellant had permitted the overweight when it is the mandate of the provision to section 73 of the Railway Act that in case of a detection, emphasis applied, my lord, that in case of a detection of overloading in the forwarding station, the railway authority should have unloaded the excess load and recovered the cost of such unloading and any charge for the detention of any wagon in that regard. The learned counsel, however, submitted that taking into the account of the weight did not exceed much, the railway authority have permitted to carry out the load, and the applicant did not raise any protest then. Further, my lord, this court has duly taken the note of section 73, and from the said, it is seen that the railway administration could not have permitted carrying out of any load beyond the capacity of the wagon. That too, when it is detected at the forwarding station. In view of the
Forwarding
matter,
station is the station where
in
the
between,
goods are loaded or in between.
in between, my lord.
What is, where is the definition of forwarding station?
I'll just check, my lord. Originating station is the beginning and destination station, and the middle stations are meant to be forwarding stations, my lord.
Where we will find that meaning? Because this forwarding station word has been used in 73 also.
Yes, my lord. My lord, the goods are being reweighed at the en route itself. That's why. Forwarding station. Forwarding.
What is forwarding station?
Forwarding station is the station where my lord loading is my lord done, my lord.
Original,
Yes,
original.
station.
Then you can impose charges only if it is detected at forwarding station.
No, no, in
But
between
that is
forwarding
the,
station and destination station.
no,
Section 73, my lord.
or at any place before forwarding station. Okay. It may be detected even any other place.
My lord.
Okay. Yes, Mr. Rathi, continue.
Yes, my lord.
Forwarding station perhaps means the originating station.
My lord.
Yes, my yes.
Yes, what is the,
My lord, even if going into that angle, if your lordship will look upon section 73, my lord, of the Railway Act.
yes. No, let us complete the para 9
Para 9.
of what you were reading.
My lord, I have already read para 9. Para 10, my lord, this court has duly taken note of the provision of section 73. And from the said, it is seen that the railway administration could not have permitted carrying out of any load beyond the capacity of the wagon. That too, my lord, beyond the wagon, my lord. That too when it is forwarding station. Emphasis applied
No,
on forwarding
no.
station, but any station will be applicable in 73. Because, my lord, as per section 73, the non-obstant portion of 73.
No, this judgment speaks about if excess weight is detected at forwarding station.
My lord.
But the 73 says if it is detected in forwarding station or at any
Any
place
place. Any place,
before
my lord.
destination station,
For destination.
which
any
is in this case.
in the en route, my lord. In the en route, it has been detected, not at the destination station, my lord. In the judgment also, it has been mentioned, my lord. Impugn judgment.
Okay, what is your submission?
If, my lord, para 10, my lord, of this judgment, this court
Yes.
has duly taken the note of provision of section 73, and from the said, it is seen that the railway administration could not have permitted carrying out of any load beyond the capacity of the wagon. That too, when it is detected at the forwarding station. In view of the matter, this court is of the opinion, as the appellant has proved that there was an additional, my lord, emphasis again applied, appellant, that is the Union of India has to prove that there was overweight, my lord. In that view of the matter, this court is of the opinion that as the appellant has failed to prove that there was an additional weight which was detected at the forwarding station as well as was held by the learned tribunal, and further, they could not have permitted overloading of the wagons when detected at the forwarding station. The charges of the additional amount from the applicant was therefore unauthorized.
In our case, my lord, it was not detected at the forwarding station, my lord. because
And
there-
it was detected
Yeah, but because
and
when
totally
facility was
Before
there.
destination.
before destination. And my
Here
lord-
in this case, my lord, at the, sorry, my lord, sorry.
Yes.
And my lord, if your lordship will look upon section 73, the last paragraph, I'll just read the last paragraph. Provided that it shall be lawful for the railway administration to unload the goods loaded beyond the capacity of the wagon if detected at the forwarding station or at any place before the destination, and to recover the cost of such unloading and any charge for the detention of any wagon on this account, my lord. Railway has to offload, my lord, the
Not
overloaded.
has to. It shall be lawful means it will not be illegal if it offload it. But it does not mean that it has to necessarily offload it. It will not be illegal if the railway remove the excess weight. That is what I understand.
My lord, in this respect, my lord, as a section 70, in this case, my lord, the judgment which I placed of MFA 31, 2012, this case was in respect of forwarding station. That why in interpreting section 70, only this observation has been made. If this observation is applicable for forwarding station, then the same observation and the principle can also be applicable in any other place before destination. That's my submission, my lord. If before destination, any place, my lord. Because how can the railway can offload travel the entire overloaded consignment if it has already detected, my lord, and in the provision it is mentioned they can bear the cost and everything. I can bear with that.
No, but 73 proviso is not mandatory that you have to mandatorily offload. It only means that it will not be illegal if you offload it and impose some costs.
My lord, there's another judgment in respect to this angle only of our Honorable High Court judgment. Yes.
No, you have understood my query.
Yes, my lord.
You have to convince this court.
Yes, my lord.
No, you show what judgment you want to show.
Yes, there is another.
One submission is that railway has failed to show that there was an overloading.
Yes.
In this judgment also, which you have relied,
No document was provided.
the railway failed to prove. Yes, what is this?
If my lords may look upon para 9. It's also in respect to section 73, my lord. Considered the submission of the Learned Council, Rule 1432 of IRCM stipulates that all weighbridge will be tested half-yearly by an inspector mechanical department. Rule 1435 stipulates that the station master who tested daily the weighbridge and the weighing machine must take a note of the
What is
test.
this IRCM?
Indian Railway Commercial Manual, my lord.
Indian.
These are statutory in nature.
Okay.
Rule 1435 stipulates that the station master who tasted daily the weighbridge and weighing machine must make a note of the test in the weighbridge register and tally book, and if it transpires that the weighing machine is out of the order, repairing of the said instrument ought to be arranged immediately. Further, my lord, as the present dispute in respect to the overloading, and that too in the presence of the railway staff after making the height for loading of coal in wagon, as such the coal loading height register as per goods tariff number so and so, wherein it has been specifically mentioned that the booking staff should ensure that the loading of the coal beyond the required height is not allowed in any case. If the coal is found loaded beyond the permissible height, the staff at fault will be taken too seriously. Emphasis applied from here onwards, my lord. The railway appellant is empowered under section 73. If there was any overloading, the same ought to have been unloaded. And as against that, the cost of such unloading or any charge of the detention of any wagon on that account was not informed to the respondent consigner. It is the contention of Mr. Day as that the detection was at the station point, and as such there is no requirement of any such notice, because immediately on this detection penalty was levied, which was paid along with the freight respondent without any process. That cannot be accepted unless some definitive. My lord, this portion which I read above is also speaking that railway has to unload, my lord. the
No,
overload.
I don't agree.
My lord,
Railway has to unload, that is not the legal requirement. Railway may unload, even if it unload, it will not be illegal. That is the plain meaning of the proviso to section 73. You convince me otherwise. But that is what this is,
it's a Supreme Court judgment.
okay. Thereafter, what is your submission?
My humble submission is, my lord, the railway ought not have traveled the overloaded consignment, my lord. Railway should have unloaded, have imposed those costs upon me. If so, my lord, overloading has been detected, my lord.
Where? How?
My lord, my reading of section 73
No,
is to
how it could have done. Suppose
Yes,
from the destinations, from the originating station and destination station, in between, before reaching destination station, they have way bridge on the railway track itself.
Yes, ma'am.
When the rail passes through the track, it get weighed.
Yes, ma'am.
So it was found that your consignment was
overloaded. Yes, ma'am.
So how it
At the time of testing itself, my lord, since overloading was detected, at the time of testing itself, they could have offloaded my overloaded consignment, which was there, my lord.
how
My lord, it's not like it is a regular travel way and the train is crossing immediately. My lord, a proper payment has been done and results, my lord. If the overloading is detected, they have to offload, my lord. That's my humble submission. Railway checks it properly.
Okay.
Payment.
Thereafter.
Yes, my lord. My lord, these two judgment, my lord. Apart from that, if your lordship may look upon the impugned judgment.
So they fail to offload, therefore they cannot impose charges. Is that your submission?
One point of submission, my lord. One point of argument, definitely, my lord. Because as per 73, my lord, there is a coordinate bench judgment, which if my lord may consider, my lord. And my lord, there is another angle, my lord, in respect to merits, my lord. At page number 18.
Yes.
My lord, in the
Page 18.
In the tabular form in respect to 479 of 2007. If your lordship is there.
For page number 18, yes. 479 refers to your case.
Yes, my lord. This tabular form is in respect to what all the documents I have submitted before the tribunal, my lord.
Okay.
Copies of the railway received, sale invoice, my lord, which my learned friend was just saying Bijak is sale invoice.
Bijak.
Yes, my lord, Bijak. Issued by Agarwal Food and Goel Udyog, money receipts, claim letter, advocate's letter, affidavit by so-and-so proprietor. Now, my lords, may kindly look upon the next tabular form, documents produced by the respondent under the subheading, my lord.
Where?
In the next page, my lord,
Yes.
documents produced by the respondent. If my lord, a page may be turned, my lord, in respect to 479 of 2007. Only do has been mentioned, not a single document has been produced by the railway.
No document.
Yes, my lord, do, not a single document, my lord.
Okay.
Secondly, my lord, at para 17 of the impugned judgment, if your lordship may look upon.
Yes.
Whereas, according to the respondent, when the consignment were reweighed en route, overloading were detected, and accordingly, penal freight undercharges, demerit charges were realized from the applicant. To substantiate their claim, the respondents have filed weighment chart only in 10 OAs, my lord, not in my case. Though in 45 OAs, the respondent claimed that there was overloading. Besides, to prove that the weighbridge was in order, the respondents, that is the railway, filed weighbridge verification certificate only in 3-4 OAs, not in my case. 479 2007 is not there, my lord, in any of this case, my lord. Not even a single document, my lord. If they are testing, a result is shown. If their allegation is that you have conducted overloading of the wagon, at least the weighment result may be given, verification certificate. Not even a single document has been produced, my lord.
Okay.
My lord, we have also preferred a discovery application. Our discovery application was allowed, my lord. However, none document was produced, which was willful disobedience of the discovery order, my lord, under order 11 rule 21 of CPC, my lord. Babbar issuing Supreme Court judgment, my lord, lordship is aware I am not placing that judgment.
What judgment?
My lord, in respect to order 11 rule 21 of CPC, my lord, willful disobedience of discovery order whenever there is adverse interference may be drawn upon. Yeah, concept.
Para?
Yes, sir. Para 25, my lord. 24, my lord, 24. Second line. The principle governing the court's exercise of its discretion under Order 11 Rule 21, as already stated, it is that it is only when the default is willful and as a last resort that the court should dismiss the suit or strike out the defense when the party is guilty of such contemptuous conduct and there is a willful attempt to disregard the order of the court that the trial of the suit is arrested. Applying this test, it is quite clear that there was no willful default on the part of the defendant on the court's order under Order 11 Rule 18, production of documents for inspection. Consequently, the order passed by the trial court so-and-so striking of the defense of the defendant must be vacated and the trial must proceed afresh from the stage of the defendant was not permitted to participate. It was further contended that the High Court was in error in observing that, in view of the clear language Order 11 Rule 21, the defendant has no right to cross-examine the plaintiff witness. A pursual of Order 11 Rule 21 shows that where a defense is to be struck off in the circumstances mentioned therein, the order would.
No, have you filed any application under Order 11 Rule 21?
Discovery application, not under Order 11 Rule 21, but my lord, a discovery application was filed by me and order.
Where is that? A reference to that. What was your prayer?
My lord, it is in the lower court record if I have the application.
If you are making some submission, you have to be.
I can look.
If you are making some submission, you have to be ready with it.
Apologies.
Kutul, record down. What is your submission?
My
that you
submission
made an application for discovery of.
Which was allowed, however,
They
my lord,
failed
the
to
railway
produce.
failed to produce.
So when you made that submission, When you made that application and by which order it was allowed, that has to be, and therefore your submission is that an adverse inference should be drawn against them.
Yes, my lord.
What is the order, date of order? Your application is at page number?
Original application.
No, that discovery application.
Yes, my lord, that's here. 32.
When it was allowed, what was prayer made in the discovery application?
I sought for railway may produce original forwarding notes, loading tally book of booking station meeting compliance of IRCM rule 1512 and 1513, IRCM rule 1402 and section 64. Copy of unloading tally, delivery deficiency message of destination point,
Okay.
meeting compliance of IRCM rule 1715, 1716, 1718, 20 and 1721. Copy of disposal of so-called excess weight or bags in terms of section 73 and 78 of Railway Act. The respondent railway may be directed to produce full delivery records and so-called excess bags, copy of weighband chart and railway weighbridge, copy of fitness certificate. Nothing was produced, my lord. The respondent railway, my lord. I'll just produce the order as well, which allowed the same. my
In
lord.
this case, whether the excess weight was offloaded?
Not offloaded.
Not.
Not offloaded.
Only at the destination point, it was again not reweighed.
Not really, my lord. Because my lord, it can be where weighbridge is available, my lord,
Okay,
only there can.
Okay.
And my lord, this application was made, my lord, in 2015, my lord. And my lord, I'll produce one judgment, my lord, that beyond 6 months, my lord, railway is not required to, my lord, to my lord, keep those records, my lord.
My lord, those 6 months.
What
my
was the order?
And my lord, the order, my lord, the loading was made in 2006, my lord. And they, my lord, discovery of documents, my lord, application was made in 2015.
No, therefore I am seeking what order was passed on their application. If there is an order of the tribunal,
Yes, my lord.
it has to be complied with, or you could have agitated.
Hesitation, my lord. That is correct. That is correct. my lord. My lord, here, my lord, it is recorded that we have not, could not produce, my lord.
Okay, any other submission? You
Yes, my lord.
later on flag it.
Yes, my lord, I'll flag. Apologies, my lords, but there is not even a single order inside the LCR. Single order, not even a single order.
Order will be there.
Only the impugned judgment is there.
Okay, what? Proceed with your
No,
submission.
my lord, they have not produced any document, and the onus is proof upon the railway to show that overloading was there, my lord.
Anything?
Yes, my lord. My lord, I have flagged the railway receipts. My learned friend submitted, it was said to contain, my lord. Highly misleading statement. It was booked under railway risk category, my lord. I flagged the railway receipts, my lord.
So, my lord, there is a stamp below the railway receipt, my lord, which says, my lord, loading not supervised by railway, my lord. Not you will find, my lord, at the below of the railway receipt. At the bottom of, my lord, railway receipt, my lord.
Supreme Court के references है. So वो Supreme Court case है.
No, sure.
No, what is the submission, Mr. Rathi?
My lord, this consignment was booked under railway risk rate, my lord. And whenever a consignment is booked under railway risk category, my lord, the entire supervisory and everything has to be done by the railway. So at the time of loading, if it is supervised by the railway, how come overloaded wagons can be overloaded, my lord? That is my humble submission, my lord.
On what basis you are saying that it is railway risk category?
My lord, in the risk rate, it has been mentioned RR. In the box, my lord, in the risk rate, it has been mentioned.
Which box?
My lord, third box from the left at top.
Okay.
If RR has been mentioned in all the railway receipt, my lord. It's a railway risk, my lord. The provision is also there in respect to this.
Which is the provision?
Yes, my lord.
Yes, where is the seal?
Yes, my lord.
What is your name?
Z Goswami, madam.
Mr. Goswami, where is the seal which you were?
My lord.
Seal of,
Yes, my lord. My lord, I'll show, my lord. Lordship, I have the Xerox copies, my lord. The bottom, my lord. Bottom, my lord. Please focus on, my lord.
what?
My lord, it is written, loading, not supervised by railway staff. Lordship, may kindly see my document, my lord. It is quite visible here, my lord. It is visible. Not supervised. Bottom, my lord. Bottom, my lord. Slightly legible, my lord. Not supervised by railway staff.
Direct loading.
Yes, my lord.
My lord, I'll just produce that judgment. I'll give that judgment, which is our honorable court judgment, which is stating if the consignment is booked under railway risk, the plea of said to contain cannot be taken by the railway. I'll produce that judgment, my lord, after argument. I'll mark that and I'll give that, my lord.
Okay.
Yes, my lord. 63. My lord, just one provision, my lord. 24. If your lordship may look upon section 63, my lord, provision of risk rates.
Yes.
Where any goods are entrusted to a railway administration for carriage, such carriage, except where owner's risk rate is applicable in respect to such good, be at railway risk rate. Any goods of which owner's risk rate or railway risk rate are in force may entrusted for carriage at either of the rates, and if no rate is opted, the good shall be deemed to have been entrusted at owner's risk rate, my lord. My lord, in whenever a railway risk has been booked, my lord, 15% of the freight has been extra charged upon me. The duty of the railway is to do supervisory, my lord. I'll produce that judgment, my lord. That judgment is very well interpreted, my lord, in this aspect, my lord. Said to contain and railway risk. Thus, my lord, this plea cannot be taken. And lastly, my lord, my learned senior friend has submitted in respect to principle of natural justice, which has been overruled by the Supreme Court, my lord. 333 judgment, my lord, giving opportunity of being heard. That judgment. If my lords may look upon the Supreme Court judgment, which has been cited by my learned senior friend, reportable Supreme Court judgment.
Yes.
At para 11. Your lordship is there at para 11.
Yes.
My lord, this case is totally different. The facts of this case and my case is totally different. Para 11, my lord, what is it saying? In very nature of things, on raising such demand, when excess weight has been detected at the time of offloading, my lord. Firstly, my lord, there are two submissions, my lord, from based on this first line. That the as per section 73, even Honorable Apex Court at the time of interpreting has deemed to be understand that at the time of offloading, that whenever excess good has been detected, it has to be offloaded, my lord. My first submission is that. And second submission is that, my lord, and opportunity of being heard is not required when excess weight has not been offloaded, my lord. When the excess weight has not been offloaded, opportunity of being heard is required. But when the excess weight has been offloaded, at that point, opportunity of being heard is not required because the goods can be computed at the destination. How much quantity of the goods has been offloaded and how much quantity of the goods is at the destination station. That's why opportunity is not required. But when they have not offloaded, opportunity of being heard must be granted, my lord. Principle of natural justice, my lord.
No, they have not produced the weighment chart before the tribunal.
Yes, ma'am.
But whether they have communicated to you before you filed the original application,
In respect to what?
while imposing the penalty.
My lord, the penalty has to be imposed before the delivery of the consignment, my lord. Section 73, as per section 73, whenever a demand has to be raised only before the delivery of the consignment. If any demand is raised after the delivery of the consignment, it will be untenable. So it's a very settled position of law. Jagjit Cotton Textile Mill has
So
also-
before the delivery of consignment, they
when they have imposed a penalty upon me.
and at the time of imposing penalty,
Yes, my lord.
whether that weighment chart was given to you
No, my lord.
at that point of
No,
time.
my lord. It was not given.
At no point of time
No
it was.
point of time. That's why, my lord, some opportunity of being heard should be given. That they are unilaterally imposing penalty upon me. They are not giving me weighment chart,
Okay.
not verification certificate. And my lord, I am emphasizing on this principle of natural justice angle because the Honorable Apex Court has definitely overruled our full bench judgment of our Honorable High Court judgment.
What was the full bench judgment?
My lord, I have the full bench judgment.
Which says that opportunity of
Being heard must be granted.
give that judgment.
Starting from para 18, my lord.
No, you need not to read it. You just tell me the relevant paragraph.
From para on 18 onwards, my lord, all these are relevant.
Where it says that while imposing penal charges,
Opportunity of being heard, my lord. At para 18, first line itself, second line, my lord.
Okay, okay. Okay, anything else?
Nothing.
You have anything to say?
My lord, the Honorable Supreme Court judgment is said, my lord, is my lord so cause requirement regarding requirement of so cause notice, my lord. It is my lord clearly stated, my lord, that my lord, the full bench judgment is, my lord, of this Honorable High Court is, my lord, to that extent only that since we have not given them an opportunity of hearing, so it cannot be imposed. My lord, that was, my lord, set aside by the Honorable Supreme Court. So, my lord, my point is that, my lord, there is no requirement of, my lord, and section 73 also not say about any, my lord, requirement of notice, my lord. We can, my lord, just wait it, and my lord, we can impose the punitive charges, my lord. And secondly, my
No,
lord,
but while mentioning the punitive charge,
my lord,
you have not given them any weighment chart. So you can mention any rate, how they will know.
my lord, actually, my lord, thing is this, my lord, railways, my lord, it's a state, my lord. My lord, there is no, my lord, such, my lord, we do not have any enmity with them, my lord. But we have waited, my lord. The government officers have waited the same, and then, my lord, we have imposed the penalty, my lord. So many trains are coming, my lord. My lord, if we can show the list, my lord, in some of the
Okay,
my lord, we have not imposed, my lord.
Okay.
Some of the, so, my
So
lord, in good faith, my lord, they are working, my lord.
So your submission is that railway can impose any charges on good faith without intimating the.
No, my lord, not.
And that should be condoned only on the ground of good faith.
No, not my lord. My lord, on
Okay,
visit, my lord, section 73, my lord. I will not go beyond that, my lord. I'll read it out once again.
No, you have read it.
My lord. My lord, that is my lord. My submission is that, my lord. Only
Heard,
second.
Mr.
My
UK.
lord, one more judgment I would like to place, my lord. One judgment.
Which judgment?
Yes, my lord. This is my lord. Just a minute. My friend has appeared. My friend has appeared in this, my lord. It's a recent judgment, my lord. My lord, I would like to read from page 3.
What you want to show?
Para 14, my lord. My lord, regarding my lord, 110, my lord, section of burden of proof, my lord.
Yes.
At this stage, the section 110 of railway comes into place. So a brief visit of the said section of law would be fruitful in it is read as under. My lord, that is now, my lord, para 15, my lord. I will not read this section, my lord. According to section 110 of this Act 1989, the burden of proving monetary loss actually sustained shall be on the person claiming the compensator. It shall not be necessary for him to prove how the loss was caused. In the case before the tribunal, the respondent did not adduce any oral evidence. It relied upon documentary evidence which were available before the tribunal. Out of 48 tank wagon, 38 number of tank wagon were found without seal on the top bottom valve leakage and without nuts and bolts, etc.
No, what you want to show? What you?
My lord, regarding burden of proof, my lord, they have to prove it, my lord. The amount quantity, my lord, and along with that, my lord.
What they have to prove?
My lord, that
in this case,
my lord, they are saying that there is no overweight, my lord. But there is no document to prove what is the actual quantity of the goods, my lord. No bizu was produced, my lord.
No, they have deposit submitted.
My lord, the only RR, my lord, I have, my lord, as
RR as well as
my lord, RR,
sales invoice.
my lord, RR, my lord, is a declaration, my lord. On the basis of that, my lord, we have only, my lord, calculated the freight, my lord.
Okay.
Now,
This
when, my lord, on way, we, my lord, found that there is overweight, then only we have imposed, my lord. So, my lord, RR does not, my lord, it does not prove anything, my lord.
My lord, the burden of proof.
okay.
Only.
Heard Mr. UK Goswami.
My lord, UK Goswami known as G Goswami, my lord.
Sorry, heard Mr. G Goswami. You are standing counsel.
My lord, railway.
Then it's standing counsel NF Railway for the appellant. Also heard Mr. D. Rathi, learned counsel for this. Learned counsel for the respondent number 1. Stop. You may take your seat. This appeal under section 23 of the Railway Claims Tribunal Act 1987 has been filed against the common judgment and order dated 24/11/2016 passed by the Railway Claims Tribunal Gauhati bench in original application number 479/2007, whereby the Railway Claims Tribunal had directed the present appellant to pay to the respondent number 1 . What you were directed to pay? Directed to excess, or you were directed to pay the under charges and demurrage charges imposed on the respondent number 1 by the appellant, along with an interest at the rate of 9% per annum from the date of filing of the original application till the date of realization. The next para, the facts relevant for consideration of this appeal, in brief, are that the respondent number 1 had booked a consignment from
Tilda to new Guwahati, my lord, at para 1 of our, my lord, appeal, my lord. Tilda to new Guwahati, my lord, case 3, my lord.
from tilde within bracket TLD to
New Guwahati,
New Guwahati within
NGC.
bracket NCG,
NGC.
NGC. The consignment booked by the respondent number 1 said to contain rice. What was the consignment?
Right.
Rice,
Right, right.
rice.
My lord, at page 39, my lord.
Said to contain 3,760 quintal of rice. The said consignment was booked at the rate of 109.46 per quintal. Stop. It is also stated that the distance between originating station, that is tilde within bracket TLD, to the destination, that is New Guwahati within bracket NGC, is 1,570 kilometers. And the freight calculated on the said consignment was to the tune of rupees 4,11,570. Stop. However, the present appellant, owing to excess weight of the aforesaid consignment imposed undercharges, impose the, what is the charge?
Penal undercharge
Penal
for
undercharge,
overloading of the wagon.
penal undercharges to the tune of rupees
Malat, it is
31,733,
33.
as well as demurrage charges at the destination station to the tune of rupees 20,475, and thereby the respondent number 1 was made to pay an excess charge of rupees 57,962. The present respondent preferred an original application before the Railway Claims Tribunal Gauhati bench, claiming refund of the excess charges paid by him. The said original application was registered as OA number 479/2007. The respondent filed written statement.
Yes.
The said original application was taken up by the Railway Claims Tribunal along with 45 other original applications where similar questions of law was involved, and ultimately by the impugned judgment dated 24/11/2016, the Railway Claims Tribunal directed the present appellant to refund the excess freight refund the excess charges imposed on the respondent number 1 along with the simple interest at the rate of 9% per annum. Stop. Learned standing, Mr. G. Goswami, learned standing counsel for the appellant has submitted that the Railway Claims Tribunal, the respondent authority had lawfully imposed the punitive charges for overloading the wagon by the respondent number 1. He submits that though a full bench of this court in the case of Megha Technical Engineering Private Limited versus Union of India within bracket, writ appeal number. Was it a writ appeal?
Yes,
Writ appeal number 333/2010 had held that has held that under section 73 of the Railways Act 1989, the punitive charges cannot be imposed without affording an opportunity of being heard to the person on whom the charges were sought to be imposed, However, recently, the Apex Court, in the judgment of Union of India versus Megha Technical and Engineers Private Limited, within bracket, SLP C number 8024/2018, has set aside the judgment of the full bench, aforesaid judgment of the full bench of this court, and has held that when excess weightage has been detected at the time of offloading, it would be practically difficult for the railways to issue a show cause notice to consignor or the consignee and to hold a mini trial to determine the question of excess weight, and thereafter levy of compensatory charges. He submits that therefore the railways were well within their right to impose the excess and to impose the punitive charge for overloading of the wagon by the respondent number 1. He submits that the judgment of the he submits that the impugned judgment of the Railway Claims Tribunal is also bad in as much as it failed to take into consideration that burden of proving that the weight declared by the consignor at the time of issuance of railway receipt to him and that is the correct weight of the consignment, and no penal fines should be imposed on him, is on the applicant who moves the original application before the Railway Claims Tribunal. In view of the provisions of Section 110 of the Railways Act 1989, he submits that the Railway Claims Tribunal, by holding that the appellant has failed to, by holding that it was the burden of the appellant to prove that there was overloading of the consignment. As Section 110 of the Railway Claims Act cast such burden on the respondent number one only. He further submits that the he also submits that when the railway receipts are issued to a consignor and he further submits that though railway receipts are prima facie evidence of the weight and number of packages stated in the said receipt, however, in a case where the consignment in a wagon load and the weight or number of packages is not checked by a railway servant, authorized in this behalf, and a statement to that effect is recorded in such railway receipt, the burden of proving the weight, or as the case may be, the numbers of packages stated therein shall lie on the consignor. And as such, in this case, full stop. He submits that in the instant case, in the railway receipt produced by the respondent number one before the Railway Claims Tribunal clearly shows that the said receipts were issued without any supervision by any of the railway officials. And hence it was incumbent on the respondent number one to prove the weight of the consignment in the proceedings before the railway tribunal. He submits that as the respondent, as original applicant before the Railway Claims Tribunal, had failed to relieve the burden cast on him under Section 65 within bracket, under proviso to Section 65 within bracket 2, as well as Section 110 of the Railways Act 1989, the tribunal was wrong in allowing the original application by shifting the burden to the Union of India. In support of his submission, Learned Standing Counsel for the appellant has cited following rulings. Union of India and others versus Megha Technical and Engineering Private Limited, within bracket, SLP number 8024/2018. Number 2, Union of India versus Messrs. Indian Oil Corporation Limited and another. Indian Oil Corporation Limited, within bracket, judgment dated 6/1/2026 in MFA number 76/2014. Any other submission?
My lord, and that regarding my lord, the document, my lord, the judgment, my lord, I do not have just now, my lord. I'll produce the judgment, my lord, regarding 6 months, my lord, that the railway should keep the documents for 6 months only, my lord. Preserve the document for 6 months, my lord.
Learned counsel for the appellant has also submitted, has also produced during hearing, during the course of hearing, the weighment chart which he claims to have submitted before the railway tribunal. However,
This is, my lord, may not be true, my lord, because the tribunal has recorded that no document has been produced, my lord. I cannot, my lord, lie before this, my lord. That is the recorded, my lord.
produced a weighment chart wherein the excess weight carried by the excess weight in case of the consignment booked by respondent number 1 has been mentioned. However, he fairly submits that said excess weight has not been, said weighment chart was not produced by the railways before the Railway Claims Tribunal as reflected in the impugned judgment. Stop. He further submits that though a discovery application was filed by the respondent number 1 before the Railway Claims Tribunal, however, the railway are not required to preserve the documents relating to booking of consignment and beyond 6 months.
As ruled by the MFA 269 of 2010, my lord. Judgment in MFA 269 of 2010.
6 months.
Yes, my lord.
In support of his submission, he has cited a ruling of this court in the case of
MFA
in the case of within bracket MFA
269 of 2010.
269 of 2010. Ito ulai lobo paribo na? 2010. Stop. He submits that railway he submits that the appellant has legally imposed the punitive charges when on the respondent number 1 when the consignment book by him was found to be overload, found to be excess when same was weighed before the destination station by the railways, and hence he submits that the Railway Claims Tribunal had erred in allowing the original application filed by the respondent number one. Therefore, he prays that this appeal may be allowed and the impugned judgment of the Railway Claims Tribunal may be set aside. Stop. On the other hand, Mr. R. Rathi, Divesh Rathi for learned counsel for the respondent number one has submitted that the tribunal has rightly allowed the original application filed by the respondent number one. Respondent number one as the appellant had failed to adduce any evidence before the Railway Claims Tribunal to prove that the consignment booked by the respondent number one was in excess of the weight mentioned in the railway receipt. He submits that next para. He submits that even assuming but not admitting that if the consignment was found to be overweight when weighed by the railways, it was incumbent upon the appellant authority under proviso to Section 73 of the Railways Act that it should have unloaded the excess amount and recovered cost of such unloading and any charge for detention of wagon in that regard. However, nothing of that sort was done in this case, which belies the claim of railway authority regarding overloading of the consignment by the respondent number one. He also submits that the Railway Claims Tribunal was right in holding that the railways, within bracket, present appellant, had failed to prove that there was an overloading of consignment, as no evidence was adduced by the railways before the Railway Claims Tribunal. He also submits that though in some of the original application which was taken up along with the original application filed by the present respondent, the railways had filed some documents in support of its contention. However, as regards the present respondent number one is concerned, they did not file even a single document in support of their contention. Learned counsel for the respondent number one has also submitted that before the Railway Claims Tribunal in the proceeding of original application number 479/2007 filed by the present respondent number 1. He had also filed an application for discovery of क्या लिखा last line discovery of documents under section 18 within bracket 3 within bracket B of Railway Claims Tribunal Act 1987. However, the railways failed to produce even a single document. He also submits that though the judgment of the full bench of this court in the case of Megha Technical and Engineering Private Limited within bracket versus Union of India within bracket Supra has been set aside by the apex court in the case cited by learned Standing Council of Railways. However, he submits that the facts of the said case are distinguishable from the facts of the instant case inasmuch as in the said case the apex court observed that when the excess weightage has been detected at the time of offloading, it would be practically difficult for the railways to issue show cause notice. Whereas in the instant case, no offloading was done, and it was the claim of the railways that excess weight was found when the wagons were weighed in between the originating station and the destination station, and nothing was informed to the respondent number 1 regarding the basis of imposing punitive charges under section 73 of the Railways Act. Any submission?
My lord, the 6 months thing, my learned senior friend submitted that they have to maintain record only for 6 months. My lord, I am also placing the judgment which is saying if the notice is served within 6 months, they have to keep the record. If notice is not served, claim notice under 106 is not served, then they can destroy the record in 6 months. But if notice is served, they have to keep it throughout the period.
My lord, my judgment is, my lord.
Okay. He also submits that since the railway, since the appellant has failed to abide by the order of the Railway Claims Tribunal regarding discovery application filed by the present respondent number 1 before the Railway Claims Tribunal. An adverse inference may be drawn against the railways that they do not claim any, they do not possess any such documents. He therefore submits that the Railway Claims Tribunal has rightly directed the railways to refund the punitive charge as well as demurrage imposed on the appellant, and same needs no interference by this appellate court, by this court in exercise of its appellate jurisdiction. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record, including the records of the original application, including the original records received from the Railway Claims Tribunal. Stop. I have also gone through the rulings cited by learned counsel for both sides. Remaining part reserved.
My lord, my lord.
Heard both sides. Hearing concluded, judgment reserved.
Much obliged.
Item 11, my lord. but-
At two,
At two.
at two we'll take it. Everything at
May it please your lordship.
yes.
Lordship, with the consent from the appellant side, I would like to adjourn item number 27 for the day. I need to seek some further instruction from
Item number
27, your lordship, in the supplementary list.
heard Miss, what is your name?
Bora.
Heard Miss A. Bora, learned counsel for respondent number 1, who prays for an adjournment on the ground of personal difficulty. She submits that she has informed learned counsel for the appellant regarding her prayer for adjournment, who does not have any objection to her prayer. Hence, the same is allowed.
Lordship, a date may be fixed, kindly.
Let this matter be first week of March,
Last week of March, if possible.
last week of March. Let this matter be listed on 24th of March.
Much obliged, your lordship.
Mati Duke.
Item 11.
11, we'll wait for some time. Let PP come. Public prosecutor. As soon as he comes, we'll take it up.
Your worship starts any matter.
Item 19.
Any mentioning? Yes.
May I please your lordship, I am for supplementary call this for item number 26. Kindly, the matter may be adjourned for the day
Why?
because my senior
What is your name?
Espal.
You have informed the other side?
No, your lordship.
No, you have to inform. Then only you may. Man,
Lordship, may I please, lordship?
yes.
I am for the appellant, lordship. Actually, I have a medical appointment this afternoon, lordship, at 4 p.m. So kindly take the matter on some other date, lordship.
My lord, I think we let him complete his part, my lord. There is no problem. Let him start. Because it's
No.
all pending matter, my lord.
If we start, we have to finish.
Yes, man, I will complete my part, my lord, but my lord, can you see that position is that all matter, my lord.
We'll fix it next Tuesday.
Next one.
Next Tuesday possible, hai?
Lordship, if possible, in the month of March, Lordship.
No, my lord, it's a two
First
Tuesday,
week
my
of
lord,
March, first week of March.
Obliged, Lordship.
Date may kindly be.
Okay. Heard, Mr. What is your name?
UB Sharma, Lordship.
This is item number
19, my
19,
lord.
Lordship.
19. Heard Mr. UB Sharma, learned counsel for the appellant. Also heard Mr. S. Chamaria, learned counsel for the respondent. Learned counsel for the appellant has prayed for an adjournment on the ground of some medical urgency on his part. Considering the submissions, the prayer is allowed. Let this matter be listed on 5th of March.
Fifth, my lord, I think, no, Thursday.
Thursday,
Lordship, can it be otherwise 10, my lord, 10 Tuesday? 10.
10th of March.
Okay.
Obliged, Lordship.
Item 20.
PP covered the.
May it please your lordship. The appellant is the plaintiff, lordship. Plaintiff filed a suit by annexure 1, page 11. Prayer portion I am reading, lordship, that is page 26.
Yes.
Para 20. Declaration that the plaintiff is the absolute owner of the suit land A. Cancellation of sale deeds number 239 dated 24/1/1985. Sale deed bearing deed number 309 serial number 483 dated 14/3/2022. Cancellation of mutation order dated 4/8/1986 in Chita mutation for the year 1986. Mutation order dated 4/7/2022 in mutation case number DIB so-and-so, cancellation of partition order dated so-and-so in partition case number so-and-so, and cancellation of patta number 452 of Bongal Gaon, Dibrugarh, Moja, all orders passed by the circle officer, Dibrugarh East Revenue Circle, Dibrugarh. Permanent injunction restraining the defendant number 1, 2, 3 from disturbing the plaintiff and from making any construction on the suit land described in the Schedule A and any other reliefs, lordship. The case of the plaintiff is that, lordship, he is the owner of a plot of land and the respondent fraudulently executed some sale deed, lordship, and by that, lordship, they are disturbing in the peaceful possession of the plaintiff. While suit was filed, lordship, the plaintiff has made list, respondent number 1, 2, 3 private respondent. Kindly see, lordship, page 11 and 12. One Lisa Gurung as defendant number 1, one Binit Kumar Jain as defendant number 2, and one Shikha Jain, defendant number 3. Now, Circle Officer 4, Deputy Commissioner 5, and Chairperson Dibrugarh Development Authority Dibrugarh as defendant number 6. While filing the suit, plaintiff sought for leave under 82 of CPC from the court, and leave was accordingly granted in respect to defendant number 4 and 5. But as respondent, defendant number 6 was made party as main defendant, no notice was served under section 60 of the Assam Town and Country Planning Act.
Assam Town and Country Planning Act. What is the provision? What it provides?
Section 60. It says bar to suits prosecutions in certain cases.
Yes.
No suit, prosecution, or other proceeding shall lie against an authority or any officer or servant thereof, or any person acting under their direction, or any government officer or servant employed for the purpose of this act for anything which is in good faith done in pursuance of this act, or any rules made thereunder. No suit, prosecution, or other proceedings shall lie against any officer or servant of the authority or any government officer or servant employed for the purposes of this act for anything done under this act, unless the previous sanction of the state government has been obtained and until the expiration of 2 months after notice in writing has been given to the person to be sued, clearly stating the cause of action and the nature of relief sought, etc. So as per section 2A, unless the previous sanction of the state government has been obtained, in this case, 82 leave was taken from the court by the plaintiff. Injunction petition was also filed. I have enclosed all injunction petition. And thereafter, the private respondent 1, 2, 3, they filed an application praying for rejection of the plaint on the ground that section 60 notice was not served upon the chairman. Their petition is at page 52, annexure 4. That the above noted case is pending before this court, that the defendant number 1 is represented by her attorney, Ms. Vineet Jain. Due to shortage of time, the defendant number 1, 2, and 3 could not file written statement today, and defendants may be allowed another date to file written statement. That the defendants beg to state that the Honorable Court may be decided first the maintainability of the suit for non-serving of notice under Section 80 CPC and non-taking leave and non-service of notice under Section 60 of Assam Town and Country Planning Act before proceed with the suit to save the precious time of the court. That the defendants beg to state that the Honorable Court has power to reject the plaint so moto for violation of the mandatory provision of the law. It is therefore prayed that Your Honor may be pleased to take note of this petition and allow another date to the defendant number 1, 2, and 3 to file written statement and decide the suit on the point of maintainability first and pass necessary order. This petition was considered by the learned trial court by the impugned order, page 57. Relevant portion I am reading, Lordship. The impugned order, Lordship, that is 59. These are the orders passed in the plaint, in the suit after filing of the plaint.
57 or 59?
57, the earlier orders passed in the suit. Title suit was registered. Page 57, Your Lordship will find the second paragraph. The plaintiffs have filed a petition, right petition number 732/23, praying for granting leave for proceeding with this suit under section 82 of CPC by waiving the notices upon the defendants. Considering the emergent nature of the suit, heard the learned counsel for the plaintiff, peruse the petition, also peruse the plaint and supporting documents annexed herewith. Considering the urgency involved in the suit, the prayer is allowed, register as title suit. So leave was granted to the plaintiff for non-serving of notice under section 80 of CPC. But impugned order is page 59. Second paragraph. I have already heard the learned counsel for both the parties. Peruse the petition number so and so. It appears that the defendant number 1 to 4 have challenged the maintainability of the suit on the ground that the suit has been filed without serving notice against the government under section 80 CPC and also without serving notice under section 60 of Assam Town and Country Planning Act, and hence the plaint should be rejected for violation of mandatory provisions of law. During the course of hearing, the learned counsel for the petitioner defendants have confined their hearing to the points raised in petition number so and so and prayed for rejection of the plaint. The learned counsel for the petitioner defendant has relied on the judgment of the Honorable Apex Court rendered in the case of Messrs. Patil Automation Private Limited and others versus Rakheja Engineering Private Limited. in support of her contention that if the mandatory requirements of law are not followed, the plaintiff is liable to be rejected. Thus, from a bare reading, page 60, Lordship, the learned counsel for the plaintiff has on the other hand argued that this court has already granted leave to proceed against the defendants by waiving the requirement of notice as provided under section 82 CPC. And as such, there is no question of rejection of plaint for not complying any mandatory requirements of law as alleged by the defendants. As the suit has been challenged as not maintainable for not complying with the provisions of section 60 of the Assam Town and Country Planning Act, hence the relevant provisions of law under section 60 of the Assam and Town and Country Planning Act is reproduced below. So these are the Act, Lordship, the page 61. Thus, from a bare reading of the aforesaid provision, it appears that to file a suit against any officer or servant of the authority or any government officer or servant employed for the purposes of the said act or for anything done under the said act, the mandatory requirement of serving notice of 2 months as well as previous sanction of the government has to be taken, and the Assam Town and Country Planning Act nowhere provides for any exception to proceed against the authority or any officer under the act by waiving the requirement of section 62A and B of the act. In the instant case, although the court has given leave to proceed against the government authorities under section 82 of CPC, but considering that the suit has also been filed against the chairman, Dibrugarh Development Authority, as defendant number 6, who is an authority officer constituted under the Assam Town and Country Planning Act. Hence, in my considered opinion, the mandatory provisions under section 60 of the Act has to be followed. Thus, from the aforesaid discussions and reason, it appears that the plaintiff has not complied with the mandatory provision of law under section 60 of the Assam Town and Country Planning Act, and as such, the suit is not maintainable at this stage. The petition so is allowed accordingly. So my plaint was rejected, Lordship. As rejection of plaint is a degree, so this regular first appeal. My point of argument is that, Lordship, that petition was filed by the private respondent. So the petition itself is not maintainable. It is the duty of the said respondent to file petition challenging the rejection suit, Lordship. Only it is given to the concerned authority to file petition praying for rejection of plaint, Lordship. The private respondent has no right to file a petition challenging the suit on the ground that no notice was served upon the other defendant, Lordship. And in the suit, your Lordship will find, though he was made defendant number 6 as a defendant, but not as a pro forma defendant, but there was no prayer in respect to defendant number 6. There was no claim by the plaintiff in his suit praying any direction to be done by the defendant number 6. Only there are some allegations that the defendant, with the help of defendant number 6, obtained permission while executing the registered sale deeds. So that is the only allegation against defendant number 6. Now I'll come to the pleadings of the plaint, Lordship. I'll show that there was no prayer in respect to defendant number 6.
No, sir. Assuming that there is no prayer,
Lordship.
then whether the requirement of section 60 to be may be diluted.
Not required, Lordship. He is a proper party, not a necessary party, that there was no relief claim from the defendant number 6. He is not a necessary party that the notice to be served upon him. And for argument's sake, Lordship, if I admit for argument, but I am not admitting, for assuming, Lordship, it is required to serve notice, that can be agitated only by defendant number 6, not by the private defendant. Their petition itself is not maintainable. So my humble submission before your Lordship that the order passed by the learned trial court is illegal, Lordship. It is pervert. The consideration of the petition itself is not permissible by the learned trial court. The allegations is that with the help of defendant number 6, they have obtained permission while executing the sale deeds.
You have made certain allegations against.
defendant number 6, Lordship. Page 20, paragraph 7 of last 2-3 lines, your Lordship will find there is the name of defendant number 6 appeared in my pleading, in the plaint, Lordship.
In case of a rejection of plaint, whether you can now again file, whether res judicata will
No,
be
Lordship.
barred.
If I am able to satisfy your Lordship,
No,
your
no,
Lordship will
I'm-
interfere with the.
Suppose this court does not interfere.
I'm not able to file again the same suit, they will raise a question of res judicata or section 10, Lordship.
No, you comply with because it was not on merit, it has not been decided.
But Lordship, in this case, already governments are party and notice was served, but this order itself is completely illegal. I'll satisfy your Lordship, there is a decision of this honorable court in CRPIO 203 of 2017. Yes.
No, just a query. I'm just putting a query. Apart from preferring an appeal, was it open for you to file another? Was there any bar
They will raise a point that you
by complying with the mandate of 60?
later on, the defendant will raise a point that the first suit was rejected, so my second suit is not maintainable.
Suit was rejected because
On the ground of non-service of notice upon defendant number 6.
but
If I do not challenge the order, Lordship, this objection may they take in future, Lordship.
okay. Yes, what you want to show?
Page 3, your Lordship will find paragraph 4.
Yes.
The only issue, paragraph 8, page 4. Therefore, the only issue which exists in present revision is that whether the petitioner, being a private defendant in the suit, can question the maintainability of the suit on the ground of non-compliance of section 80 CPC. In that case, section 80 CPC was raised by the private defendants. This court in the case of Nandita Acharji Supra has held as follows. I have considered the rival submissions of both the parties and perused the lower court records and the impugned order. It is to be noted that respondent number 7 is the editor of Assam Tribune, and obviously he is not a government officer, and as such he has no locus standi to challenge the violation of section 82 of the CPC. On the case of Kanakku Karthayani Pillai, Narayani Pillai and others versus Nilachanta Pillai, Raman Pillai and another, AIR 1969 Kerala 280, the Honorable Kerala High Court has held that the benefit of the section 80 CPC is available only to the state and its officers and not to others, and it was held that the defect of section 80 CPC cannot be urged by the appellant in the said case. In the case of Istiaq Hussain, Abbas Hussain and Jafrul Islam Afzal Hussain and other, AIR 1969 Allahabad 161, a similar view has been taken by the holding that the appellant in the said case was not a proper party to raise the issue of defect to compliance of section 80 CPC. In the present case in hand, it is seen that the state of Assam is only a pro forma defendant and no relief has been claimed against the state. Moreover, the suit has been allowed to proceed ex parte against the state. Therefore, having not contested the suit, it must be held that the state had waived its right to object against the maintainment of.
In this case, what is this?
State waived his right, so.
No, but in your case, whether the chairman has appeared,
No.
notice was served or not? Whether notice was served on the.
All the orders I have enclosed along with this petition, page 57. At the time of issuing notice in a injunction petition, Lordship, the injunction petition was subsequently dismissed and plaint was rejected.
No, in main suit, what was the
First date is 13/2/2023.
for filing of WS? Whether any party had filed WS, the private respondent
They
have.
sought for time for filing WS.
They have not filed.
They have not filed.
And whether notice was served on the. Because this may be one view as who will raise the issue of violation of a provision, whether that provision is mandatory or not, that is also needs to.
Already government was, leave was taken in respect to government.
No, 80 is no. Here the contention is, I think, under section 60 of
Yes, town and country.
Town
planning.
and Country Planning Act.
So whether after taking leave for some of the government officials, whether it is mandatory to take notice upon town and country planning municipal chairman. So that will be raised by only by the chairman himself, not by other persons. It is not permissible to raise this point by other defendants. So section 60 benefit non-service of notice.
Where is the bar?
These
Decisions,
Yes.
which are not binding on this court,
This is a decision by this honorable
of
body.
a coordinate bench.
Yes, Lordship. And relying on the judgment of the Nandita Acharji.
Nandita Acharji is whose judgment? Hmm. And
2016.
these judgments were in respect of section 80.
Yes. So similar to section 60 of the Assam Town and Country Planning Act. Here also the service of notice upon the government officials as mentioned in section 60.
Okay.
And moreover, one thing is that the defendant number 6 is not a necessary party. Only there are some allegations that the permissions were granted to the defendant with the help of fraudulently with the help of defendant number 6.
So he's a necessary party. How the court will find out whether
He has not yet appeared in the injunction petition. Notice was issued.
suppose he appears and
If
then
he appears
and
then-
raises same objection.
then maybe it is permissible for him. There is no bar, Lordship, if he raises this question. Notice the in the injunction petition only notice. was there.
These judgments which you have cited pertains to section 80.
Yes,
Section 80. You are trying to draw an analogy.
yes, Lordship.
Indeed.
The section 60 is similar to section 80 of CPC.
Okay. But okay, what else is your submission?
This is my submission that defendant number 6 is not a necessary party. Only there was no relief sought from defendant number 6. And this petition, which was filed by defendant number 1, 2, 3 is not maintainable. So allowing of the petition by the learned trial court is perverse. My humble submission before your lordship to set aside the order and remand the plaint to be decided by the learned trial court, lordship, as per law.
Yes.
First of all, Miller, I take strong objection regarding the word fraudulent, Miller, because Miller, this plaintiff, he has already sold his entire land, and that was we have purchased the land, Miller. I represent 2, 3, and 8, number 2, 3, and 8, Miller. And subsequent to obtaining, Miller, necessary permissions from the development authority and all, Miller, the plaintiff has already sold his entire land. He has got no land left. And secondly, Miller, regarding my petition under order 7 rule 11, Miller, I don't think he has filed any objection against my petition. At least in this,
You have not filed your petition quoting the provisions under which it has been filed. You have not quoted.
yes, quoted. It was not quoted, but non-quoting of the provision may not be fatal, Miller, as my Supreme Court has already decided. At least going by the impugn order, Miller, this is an or petition, Miller, under order 7 rule 11, Miller, for rejection of the plaint.
And so far as they have, they are concerned, they have not filed any objection. As far as, at least in this appeal, Malad is not annexed, Malad. I have not gone through the records.
No, in a case where no relief was sought against chairman, there's
Then
a,
they have raised the issue of fraud, Malad. Then obviously chairman is a necessary party, Malad. Because I say, Malad, that I have taken all the permissions from the development authority. And that is why there is an issue in that regard, Malad. And so far as my learned friend's submission regarding my Malad, my intention to file the application, whether I can file that kind of an application or not. And so far as Order 7, Rule 11 is concerned, there is no bar, Malad. And let the chairman, Malad, needs to answer the queries, Malad.
chairman is appearing. Who is appearing for? Who is the standing counsel? Who is defending respondent number 6? Huh?
But here, Lordship, chairperson was earlier represented by GA Assam, maybe as per earlier order, Lordship.
By whom?
GA Assam, Government of Assam, Government Advocate, Lordship. Lordship, may kindly see order dated 5/4/2024
No,
service complete.
his views would be necessary.
They themselves appeared, Lordship.
Can you call him,
4567.
Mr. Gogoi? Government can
Orders list of 3/4/23 online correction. Notice partial decision. On 3/4/2000.
What is the status of this Dibrugarh Development Authority? It is a statutory body.
Independent.
Independent body.
3/4/2023, the appeal was admitted and notice was issued, Lordship.
Whether notice was served.
Service complete as per 5/4/24. The 3/4/2023 order, heard MS R. Chaudhary Learned Counsel for the appellant and Mr. T.R. Gogoi Learned Counsel for the respondent numbers 4567. So no other notice.
Mr. Gogoi, you appeared for 6 also.
And no formal notice need to be issued in respect to the said respondent. So on 3/4/23, that order, Lordship. At the time of admission, and now we are in 2026, Lordship.
No, therefore I'm putting this query.
Lordship.
Suppose we allow your appeal
My question
and
is
remand it back.
that
then-
their defendant number 6 can appear and he can file his petition, Lordship.
Then the court will take again same decision.
If he files, Lordship.
Then what would be your submission?
If they do not file, Lordship, it will proceed.
Okay, what is your submission, government submission?
Also, I do not find any perversity of the order of the court below, Lordship. That's because of section 60 is a mandatory rule, Lordship. They have not served the section 60 to the respondent number 6. On that ground, non-maintainability of the petition, Lordship. On that ground, it was dismissed by the Honorable Learned Court below. It's I think there is no any perversity, Lordship. Another Lordship, they have served the section 82 notice, but not any urgency properly described described in the petition.
No, but that is not an issue in this appeal.
Lords.
The issue is whether section 60 notice is
It is mandatory,
mandatory or not.
So it is not served the section 60 notice. On that ground, it was dismissed, Lordship.
You are not representing 6.
I'm not representing this, Lordship.
Yes, Ms. Chaudhary, who is representing 6?
In the 2023, they represented, so already 3 years left, gun lordship. Suit may proceed, they will file their written statement, they may take these grounds as a preliminary lordship point, and that can also be decided. Rejection of plaint lordship, the plaintiff will be debarred from raising his point lordship before the learned trial court. In the written statement, the government as well as chairman and the private respondent, all are.
Okay, I will decide this issue. Heard anything else? Any other counsel? Mr. Gogoi, your name is reflected in more than one order.
Lord.
You should have pointed it out to the court on the second day itself. When one order you are saying maybe wrongly reflects your name. Because it is mentioned that you have accepted notice on behalf of respondent number 6.
I may contact with the Development Authority of Difficult Lordship.
No, but you have accepted notice.
Lordship.
A standing counsel is there.
They have separately engaged, Lordship. So far, I have remembered, Lordship, one time earlier, once I contacted with the Development Authority, Lordship. They told me that we will engage our advocate in further later, Lordship.
Notice will have to go.
That was not informed to the court, lordship. On last lordship, there are more than 10 occasions the matter was listed, sir. There are ample.
No, but 6 remain unrepresented.
But the petition was not filed by 6, lordship.
No, in this appeal.
Yes, lordship, the petition itself was not filed by them, lordship. There was no objection by the 6 as yet, lordship. In the trial court, notice was served to them, lordship. Notice was issued to all the respondents. My humble prayer before your lordship, let the court issue fresh some notice to all the defendants, lordship. Thereafter, lordship, even I have raised a point that this petition was not filed by the concerned defendant.
Okay.
Lordship,
This is my argument, lordship may record this. And then, lordship, on that basis, this petition, this order can be, lordship, set aside. And thereafter, on appearance of all the defendants, the trial court will decide.
Lordship,
Yes, that may be one way out.
I maybe allow a short period time, Lordship, so that I can contact with other.
No, in the trial court, also notice was not served on.
Yes, Lordship. Notice was issued.
This is an application and this is an appeal. In appeal, we have to decide the. Okay. Yes, Mr. Gogoi, what is?
Lordship, I have to check out an LCR also, Lordship. What is a lower court status Lordship, regarding government pleader have appeared on behalf of the authority or not, Lordship?
PCR is there, Lordship. We all can go through in the meantime if your Lordship take up the bail.
Okay, go through.
Yeah.
I'll take up another matter.
Lordship.
Lordship.
TCR is. TCR is.
Because you should have pointed it out to court earlier.
Lordship.
That you are not appearing for 6.
Lordship. He said. Thank you.
After some time.
After some time, we will take. PP is not there.
Should see the order of subsequent PP. Only your lordship directed to come after independent witnesses. The 6-7 days already gone. Nobody is coming up. 1 year, 7 months.
1 year, 8 months.
Or 8 months. And since May 2025, we came here lordship after 6 weeks.
When is the next date?
Next date is 2 days after. 18-2.
18
There is no
of?
chance. 18-2 of this.
18-2. We'll fix it in first week of March.
Madam, enough time, your lordship has given us so much time, madam. So many time. I think if your lordship finds there is, otherwise, madam, there is.
Oxometer.
No. It is not a Poxometer, 302.
302. 302 is also.
No, there, but offense, so far incarnation, madam, is concerned, madam. Offense is not. Question the liberty is to be given, and what is the purpose one? Repeatedly, your lordship is giving direction to them. To this, nobody is coming down. Only on that count, how long they would wait?
Let the PP come. We'll take it up.
That is.
Beleg matter. PP covered your beleg matter call. He has matter in other courts. We'll adjourn it for day. We'll take it up tomorrow, day after tomorrow.
Tomorrow. After I hear from tomorrow, at 2 madam. Or at the time his convenience, madam. Let it remain the tomorrow, madam, and we'll adjust ourselves.
Item number?
11.
I say.
Oh, here's come. Your lordship, kindly see your lordship first order, my lord, page 34. Order is dated 21/5/25. 21/5/25. Your lordship got it, my lord.
What is the story? What is the fact? What are the facts? Who died? A girl
One
died.
girl died.
And
One girl died, that is the offense, my lord, it is 302. The question is, my lord, your lordship order is there, my lord, that will not do, my lord. Offense, even there is offense, my lord, if it is otherwise, my lord, in view of the Supreme Court judgment, your lordship order, my lord, yes, whether, my lord.
no, I'm not on that.
Oh, I am on
In
that one.
302 also you will get bail, provided you make out sick.
Yes, but I am only on the length of detention at this stage, my lord.
If I may just interrupt, Lordship, on the last occasion, Lordship, a status report was called for. That is before your Lordship at flag A or B. I
sorry.
forgot. That status report may kindly be given.
Yes. Last order, your lord kindly said 1912 what, sir? First, your lord may see the order, then your lordship will find. 1912.
Status report, where is the status report?
That is in a flag, Lordship, flag A or B.
আমরা water sheet টা
It has been received, Lordship.
approved. Yes, sorry.
Lordship is found.
Yes.
আমার তো সার্টিফিকেট কপি আছে we are having certificate copy also. And is it 1912 border that will matter why? How about it? 1912.
Okay, you make your submission.
Yeah.
Let him make his submission.
Can you see the 19 order, 1912? 25. First order, can you see my order? That 34. Only on that point, my 34. First order passed on 21/5/25. And your lordship had discussed, story is there. Page 36, madam. Paragraph 11. Death is due to as per submission of them, my lord, paragraph 10, the 11. He also submitted the 7 more, that is PP, my lord. 7 more witnesses are yet to be examined. And if the accused is released, and now there is every likelihood that he may influence the witness. 21 a boy, my lord, 11 a boy. He is not an influential person, my lord. The land edition and particulars also submitted that it was the petitioner who led the police, so and so it is merit, my lord. I have considered submission. Then, on the other hand, paragraph 14, petitioner has been detained behind the bar for more than 1 year. It appears from the report that 6 more independent witnesses are yet to be examined. Considering the nature of the offense involved in this case, this court is not inclined to grant bail at this stage. As of now, he may.
What is the name of the accused?
Accused name is
Tafiqul.
Tafiqul Ali. Tafiqul Ali, 21 years age, my lord. Then you will kindly see next, my lord, in the last witness, PW6, page 53, my lord, page 53. That is already 26 March 25, page 53. Page 53. Total 20 witnesses, my lord, as per charge sheet. 53 is here. This is 26 March 25. Yeah, prior rejection of the earlier, your lordship, 21st May order. Your lordship order is 21st January, May. And this was, last witness was 26 March 25. Thereafter, page 54 onwards. Your lordship kindly see, my lord. 50, so all the order sheet we have given. Last order is legislation 29. We have given the orders now. Yes. It is already there. 29, my last order was 2995. So the present bail was filed before your lordship 28/8/25. This present one. After filing of this bail matter 7 times, but I listed, PW not examined mine. Or judgment soon. This order passed by your lordship, man. Order dated 10/1/25. paragraph 14, 219.
In this case or
No.
in earlier bill
That's on
application?
NDPS.
Oh, no, what you want to show?
I want to show length of detention. 1 year, 7 months, 6 months, 1 year.
No, that depends upon the other factors also.
Other factor is that it is stated, madam, you'll kindly see, offense, Arvindam. Offense, madam, your lordship will find, paragraph, Arvindam I have given, madam. There is 25 matters.
Where,
There are 15. Offense, madam. Your lordship will find paragraph, a 15 last person. It is well settled, bottom line, it is well settled that if the state or any prosecution agency, including the court, concerned has no wherewithal to provide or protect the fundamental rights of an accused to have a speedy trial as enshrined in Article 21, then the state or any other procedural agency should not oppose the bail on the ground that the crime committed is serious. Then 18 on what your lordship can see, 18. Very clear, said the right to speedy trial enshrined under Article 2 is not at least by the nature of the offense.
or how long you are behind the bar?
1 year, 8 months. 30 days, 8 months or 30 days. So 9 months. 1 year, 9 months.
And suppose in this case you are convicted, then what may be the punishment?
In this case, life, my lord.
Death also.
But anyway, but the arrest of the rare cases. That is not whether offense serious or not. I am not in merit at this stage. I am not at all in merit.
But the witnesses who have deposed against you,
Independent witness not examine your lordship has stated, my lord. Witnesses, all family members, not all, my lord.
only father has,
Father has.
you led the police to the recovery of
Matter
dead.
of trial, my lord, it will see, my lord. There are persons right to life and right to liberty, my lord. And this is on the face of the decisions of this court and earlier, your lordship's order. Your lordship of the paragraph 14 to 19, the lordship's order.
No.
Yes.
That is okay. But this court earlier observed that considering the nature of the offense as well as accusation against you.
The highest punishment.
Yes, independent witnesses are required to be examined. That is the only.
How long,
concern.
madam? Are you go for 4 years, 5 years, madam? That way? Since last 1 year, nobody is examining. Your lordship, what are they are not including, madam? How long it will continue? Fine. Your lordship is given on 21/5/25. Kindly see, madam. About 1 year. About 1 year. Not a single witness was examined. (21/5/25). Your lordship's order. That time, 6 witnesses were examined. Thereafter also, we waited long time. No one examined. Then again, we filed petition. Your lordship asked for status.
How many accused are there?
No, only one. Only one.
No. Yes, what you have to say? Any other submission?
My submission, length of detention, madam, I am relying on the Supreme Court decision, madam.
Yes.
Even there is offense is serious, I am entitled to get bail, madam. This is my position.
Yes.
Other so many decisions there are resting your lordship.
No, I agree with that proposition that.
So I am already on that, madam. Even if offense is serious.
But your conduct has to be
Madam,
clear.
certainly I am not on conduct now, my lord. Now suppose if for any reasons I come out acquitted, my lord, nobody knows, my lord. It is ultimately.
No, other conduct. I am speaking not about that other conduct which he will point out.
No, he will point out that I'll threaten, etc., my lord. What I am saying, my lord, this is normal argument, my certainly my lord friend has got right to say.
Let us hear
But
him.
my case,
Yes.
never asked 21 years boy, my lord.
Yes, Mr. Sharma.
Yes, madam.
Lordship, regarding merit, nothing much is left to say. Just one point I am raising, Lordship, because some more independent witnesses are there. That is in just gist and giving, Lordship. 8 independent witnesses are yet to be examined, Lordship. Here, the case rests on the recovery of the body, Lordship, and there are witnesses who were present at the time of recovery of the body, subject to him being led the police officer to the recovery. Now, the important question here, as he have pointed out, Lordship, the order dated 19/12/25, last order. Lordship will kindly peruse the last order of this court, Lordship. In the last, they are placing reliance on that order, Lordship, that they were adamant on that day, Lordship, that there has been no examination of witnesses, and so they are entitled to bail. That is the order they are harping on, Lordship. Lordship has seen it?
Yes.
Now, Lordship will kindly see the status report. Status report, Lordship will find that on 17/12/25, PWs were present, but due to adjournment sought by the defense, yes, the conduct I'm pointing out, Lordship, because it is, Lordship, 17/12/25. After 2 days, they come up before your Lordship and talk about speedy trial, Lordship. That is one aspect, Lordship, and the status report also reflects, Lordship, that 8 independent witnesses are there and 6 official witnesses are there.
Yes.
Lordship,
This conduct I was pointing out.
yes.
One time, I also put it, who is 17/12/25.
It is not the question
One-
of one.
No, I'm not conduct matter, only we filed the case on 17/18/5/20, 28/8/25. Not after that we have come, man. 28/8/25 we filed this bill, present one while.
No, but after filing this bail application, you are seeking adjournment in the trial court.
One time or the people might have, only once we have taken for last 1 year, my lord.
But on that day, all witnesses were present.
Present.
My lord, they could have, my lord, stated they could have not cost also. Court allowed them to, my lord. My question, my lord, I only once we have taken. Court allowed it, my lord. It is not that, my lord, that we have only for last 1 year, I have taken one time, my lord. Thereafter also, your lost kindness, see, after that date, my lord, 17/12, what happened, my lord? After 17/12, how many days?
Heard Mr. H.R.A. Chaudhary, learned senior counsel assisted by Mr. M. Alamgir, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Muhammad Tafiqul Ali, alias Tafiqul Islam, who has been detained behind the bars since 18/5/2024 in connection with Sessions Case number 28/2024 under Section 120B/364/302/201 of the Indian Penal Code, corresponding to the Rangia PS case number 150/2024. It is pertinent to mention herein that, and this is your which number bail petition?
Second bail petition.
It is pertinent to
One of disposal, look at and note the dates, my lord.
mention herein that prior to moving this bail application, the petitioner on earlier occasion also had approached this court
Page 34.
and earlier occasion also approached this court seeking bail. And on that occasion, this court by order dated 21/5/2025 passed in bail application number 1327/2025 has had dismissed the bail application mainly on the ground that
Page 36.
considering the nature of the offense involved in the case, as well as considering the fact that 6 more independent witnesses were to be examined at that point of time.
7 more, your losses or
7 more independent witnesses were examined at that point of time. Stop.
Present petition
In
filed
the instant case,
was filed on 28/8/25.
the petitioner is facing trial in respect of charges of kidnapping and murdering the victim girl. Stop. Learned counsel for the petitioner has submitted that the petitioner has been languishing behind the bars since 18/5/2024. And though his bail application was rejected earlier on the ground that few independent witnesses were not examined at that point of time. However, after the said rejection order, on several occasions, the case was listed before the trial court. However, till date, the independent witnesses the remaining independent witnesses are not yet examined.
I'm sorry, Lordship, may I leave to go down?
Yes.
I'm sorry, Lordship.
Not yet examined. The learned senior counsel for the petitioner has submitted that irrespective of nature of accusation leveled against the petitioner in the pending trial, he is entitled to defend his case properly and entitled to be presumed as innocent till his guilt is proved. He submits that the right to get speedy trial is a part of right to life as recognized by right to life and liberty as recognized by Article 21 of the Constitution of India. He submits that as the petitioner is seeking bail mainly on the ground of prolonged incarceration and slow progress of the trial, he may be enlarged on bail. Stop. On the other hand, learned additional public prosecutor has opposed the grant of bail to the petitioner on the ground that the case of the prosecution is mainly based on the petitioner leading to the discovery of the dead body, and there is evidence on record that it was the petitioner with whom the victim girl is alleged to have eloped, and thereafter her dead body was recovered. He further submits that on earlier occasion also, as few independent witnesses were not examined when the bail application was moved, the prayer for bail was rejected. He submits that in the instant case, though the petitioner is seeking bail before this court on the ground of prolonged incarceration, however, when before the trial court the prosecution witnesses were present, on 17/12/2025, the defense counsel sought adjournment and the PW's prosecution witnesses could not be examined on that ground. He therefore submits that the petitioner may not be allowed to take advantage of his wrong conduct, more so considering the nature of offense involved in this case, as well as materials available against the petitioner on record. I have considered the submissions made by learned counsel for both sides. Though there is no dispute to the legal proposition that every accused is entitled to get a speedy trial when he is accused of having committed an offense. However, offense stop. And if the court comes to the finding that the detention of an accused facing trial is a prolonged detention, on that ground itself, he may be granted bail. Stop. However, the question as to how much detention may be regarded as prolonged detention may differ from case to case depending upon its facts. In the instant case, though the accused is detained though the petitioner has been detained behind the bars for more than 1 year, 1 year, 8 months. However, it appears that on 17/12/20, more than 1 year, 8 months, and his earlier bail applications was rejected mainly on the ground of non-examination of independent witnesses at that point of time. However, it appears that on 17/12/2025, when the independent prosecution witnesses were present, the one adjournment was sought.
On the ground, just a advocate was suffering from some, that may be mentioned. With cost, it was adjourned.
On the ground that the engaged counsel for the petitioner was,
he could not appear as he is suffering from nail pain.
Some ailments,
Yes, some ailment.
some ailments.
So it was allowed with cost of rupees 600.
Stop. Stop. This how many independent witnesses are there?
Your lordship, oh, 8. Total remaining 8, my lord.
Out of those official,
Total 20. Total 20 witnesses.
Independent 8.
Independent 8.
One examine.
One only independent, one examined.
2 examine.
7 remains as per his lordship's order also. my lord. That was after the 6 witness was examined, my lord, exam. So 1, 2 independent. 2 examined, 7.
stop. It appears from record as well as status report dated status as well as the latest status report produced by the trial court that 8 independent witnesses and 6 other official witnesses are yet to be examined. Stop. Considering the fact that when the witnesses were present on 17/12/2025, the petitioners, the adjournment, not the adjournment was sought for on behalf of the petitioner side, this court is reluctant to grant bail to the petitioner at this stage. The trial court is directed to examine the remaining independent witness as expeditiously as possible. The petitioner may approach the trial court after examination of the independent witnesses. The independent witnesses. Petitioner may approach the trial courts for bail after examination of independent witnesses.
It takes 2 years.
If the petitioner, however, if the examination of independent witnesses takes longer time, there shall be no bar for the petitioner to move the trial court even before completion of examination of all the independent witnesses. With this observation, this bail application is disposed of.
Some time limit is given, my lord, because it will matter for last 1 year. It is continuing.
How much?
That is the, because already the
3 months.
endless
3 months.
2 months, my lord. At least so that I can come again, my lord.
Okay.
Those may be kept open, my lord.
The trial court is as expeditiously as possible je likhilu নহয় within bracket, preferably within 2 months of the date of this judgment.
Always.
Item 20.
Now what is to be done?
Lordship, in this case, on 13/2, the first order was passed, and thereafter on 27/2/2023, plaint was rejected. So no one appeared except 1, 2, 3, Lordship. And the learned trial court also did not wait for other defendant, Lordship, in deciding this petition, Lordship. This petition because this petition is between 1, 2, 3 and plaintiff, Lordship.
Yes, Mr. Tian.
Lordship, nothing to say, Lordship.
When he appeared? Yes, please repeat your submissions.
Lordship, on wide order dated 13/2/2023, page 48. First
Yes.
notice, in the miscase, notice was issued.
And in the suit,
In the suit, lordship, that is. Is 57-13-2023. Issue summons to the other defendants. Caveat was lodged by defendant number 3. We have filed our injunction petition and plain. Leave was granted on.
13/2/2023 summons were issued.
Yes, lordship.
Thereafter, when it was rejected,
27/2, lordship, after 14 days, lordship.
what was the next date fixed after 13/3?
24/3/2023.
What happened on that day?
No, lordship, before that plaint was rejected.
It was rejected on
27/2. In the month of February, lordship.
and 24/3 was the next day.
Yes, lordship, for
Okay.
service report and
Okay,
written.
heard Miss R. Chaudhary, learned counsel for the appellant. Also heard Mr. R. Chakraborty, learned counsel appearing for respondent number 2, 3, and 8. Who is appearing for 1? P. Kotoki. Also heard Mr. P. Kotoki, learned counsel appearing for respondent number 1, as well as Mr. T. R. Gogoi, who is appearing for respondent number
4, 5, and 7.
4, 5, and 7. Stop. Though, no, stop. This appeal under section 96 of the Code of Civil Procedure and then section 96 read with order 41 rule 1 and 2 of the Code of Civil Procedure 1908 has been filed by the appellant Shri Kushal Mech, impugning the order dated 27/2/2023 passed by the Court of Learned Civil Judge Dibrugarh in title suit number 19/2023, whereby the plaint filed by the present appellant as plaintiff in the aforesaid title suit was rejected as the mandatory provisions of section 60 of the Assam Town and Country Planning Act 1959 was not complied with. Stop. Learned counsel for the petitioner, learned counsel for the appellant has submitted that the present appellant, you may take your seat. Present appellant as plaintiff had filed an suit against the present respondent before the Court of Learned Civil Judge at Dibrugarh, which was registered as title suit number 9/2023. Stop. She submits that the plaintiff has claimed to be the owner of a plot of land measuring, what was the
Page 27, schedule of the suit land as referred to above, plaintiff's land, a plot of land measuring 2 katha 7 lessa.
2 katha 7 lechas. However,
There are several schedules, lordship, A, B, and C. Lordship may refer that owner of A, B, C schedule of the plaint.
plot of land as described in Schedule A, B, and C to the plaintiff. She further submits that the plaintiff had alleged in the said plaint that the private respondent number 1 and 2 have what word you have used, fraudulently
Lordship.
have
That is the pleading of the plaintiff in plaint, Lordship.
I have objection.
That is already there.
had fraudulently obtained fake sale deed and thereafter mutated their names in respect of the aforesaid land, and therefore the present appellant had prayed for relief of cancellation of sale deeds, cancellation of relevant sale deeds, and cancellation of mutation orders by which the name of the respondent was mutated in respect of the aforesaid land of the plaintiffs. Apart from the aforesaid relief, the plaintiff the present appellant had also prayed for relief of permanent injunction for restraining the present respondent number 1, 2, and 3 from disturbing the peaceful possession of the appellant over the suit land. She submits that since there was an urgency in the case and since government officials have been made pro forma respondent have been made respondent in the defendant in the efforts in the suit in the plaint. The plaintiff had prayed for leave to file suit without issuing notice under section 80 within bracket 2 of the Code of Civil Procedure. She further submits that said leave was granted by the trial court by its order dated 13/2/2023. Stop next para. Learned counsel for the appellant further submits that on 13/2/2023, the trial court issued notice to all the defendants in the aforesaid suit fixing 24/3/2023 for service report and filing of the written statement. However, before that date, the matter was taken up on 27/2/2023, on which 27/2/2023 stop. She submits that on the said date, the respondent number 1 to 3 within bracket defendant number 1 to 3 in the aforesaid suit bracket close had filed a petition which was registered as petition number 799/2023, where question of maintainability was raised on the ground of not serving notice to the government under section 80 of the Code of Civil Procedure, as well as without serving notice to defendant number 6 under Section 60 of the Assam Town and Country Planning Act, 1959. Stop. Learned counsel for the petitioner submits that the trial court, without taking into consideration that the notice, that the summons issued to respondent number 6, that is the chairperson of Dibrugarh Development Authority, Dibrugarh, were yet to return to the trial court. However, without waiting for the result of the service of summons upon the said respondent, the trial court, by the impugn order dated 27/2/2023, held that the suit is barred due to non-compliance of mandatory provisions of Section 60 of the Assam Town and Country Planning Act, 1959, and rejected the suit. So she submits that in case of other government officials, the present appellant as plaintiff had obtained leave of the court under Section 80, Clause 2 of the CPC. And as in respect of the in respect of respondent number 6, within bracket defendant number 6, she submits that as the defendant number 6 in the suit was, as no relief was claimed against the defendant number 6 in the suit, it was not mandatory for the present appellant, it was not mandatory for the plaintiff to issue notice to the said respondent under Section 60 of the Assam Town and Country Planning Act, 1959. She further submits that otherwise also the petition filed by the respondent number 1 to 3, which was treated as an application under Order 6. What is the rejection of the plaintiff? Order 7, Rule 11 CPC could not have been filed by the said defendant, and the trial court ought to have waited till service of summons on defendant number 6, that is the chairman of Dibrugarh Town and Country Planning, and Dibrugarh Development Authority. She submits that the present respondent number 2, 3, and 4. Mr. Chakravarti, you are for?
3 and 8.
Present respondent number 2, 3, and 8 do not have any locus standi to object regarding non-compliance of the provisions of Section 60 of the Assam Town and Country Planning Act, 1959. In support of her submission, she has cited ruling of a coordinate bench in which the ruling of a coordinate bench in the case of Khalilur Rahman versus Abdul Bari Mullah and two others within bracket CR within bracket judgment dated 11/4/2018 in CRPIO number 203/2017, wherein a coordinate bench of this court has held that the objection regarding non-compliance of Section 80 of the CPC may not be raised by private defendants in a suit, as the said provision is for the benefit of government officials only, and it is for the government defendants who could have raised objection regarding not following the mandate of Section 80 CPC. She submits that same analogy may be drawn in respect of a notice to be issued under Section 60 of the Assam Town and Country Planning Act 1959. As she submits that, as in the instant case, the chairman of Dibrugarh Development Authority had not yet appeared before the trial court. The trial court had erred in passing the impugn order by rejecting the plaint merely on an application filed by the private respondent. On the other hand, Mr. R. Chakravarti, learned counsel for the private respondent, has submitted that the trial court had not made any mistake, as an application under Order 7, Rule 11 of the CPC for rejection of plaint may be filed by any of the defendant. The learned, any other submission?
As far as this application is concerned, Order 7, Rule 11D doesn't bar anyone to follow the law. And Malak, may I give at least one supporting judgment this point, Malak, wherein the same contention is being repeated by Supreme Court, Malak. This.
Yeah, you have typed copy.
I will give Malak. I can give it.
Okay.
Malak, this is Samar Singh versus Kedarnath and other.
In support of his submission, he has cited ruling of which court?
Supreme Court.
Of the apex court in the case of Samar Singh versus
Kedarnath and others.
Kedarnath and others reported in
Supplementary SC
1987 supplementary SEC 660, wherein the apex court has held that what has been held.
Yes, Malak. That para. In para 5, Malak, may I read, Malak?
What was the issue in that case?
The election petition, the Order 7, Rule 11.
On what ground? On what ground? No, on what ground rejection was sought? Judgment to ulai logo padega nahi. Print out lo aayega.
Well, there were certain disputes regarding the symbol among the parties.
Okay.
And
Likh lo Anamika last.
Where is the relevant motion?
Reported in Swines. Stop. Okay. Not required. The learned counsel for the other respondents have also adopted the submissions made by Mr. R. Chakravarti. Stop. It is pertinent to mention herein that Mr. T. R. Gogoi, learned government advocate, has submitted that he is not appearing for respondent number 6, though on perusal of order sheets of this appeal, it appears that Mr. Gogoi had received notice on behalf of respondent number 6 on 3rd of April 2023. Thereafter, his name has been reflected as engaged counsel for respondent number 6 on the subsequent orders. Stop. You give me that citation you have given. No? I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. I'll write the remaining part in chamber.
I want to add one more judgment, that is 2007 Supreme Gauhati 216. It says that due to technical difficulties, Lordship, the suit may not be rejected. Para 11 and 13, I have highlighted.
I am remanding the suit to the trial court. It will give notice to, it will issue fresh notice to the remaining defendant. Your petition shall be considered again after appearance of respondent number 6 before the trial court.
But Lordship, this is a petition by defendant number 1, 2, 3.
Oh, yes.
They are private respondent, Lordship, and Lordship has recorded in the...
No. It will be considered again after considering the plea of respondent number 6.
Then Lordship...
I'll give more observations.
My submission is that, Lordship, this is a petition filed by private defendant that is not maintainable, as because the rejection of plaint is not maintainable, Lordship. This is an illegal order. And the other dependents, if they are...
On that, I will pass.
Lordship. Otherwise, Lordship, the defendant number 6 appear and again he will file the same petition.
That was
So
my query to you.
My submission before your Lordship, it may not be reflected in the order. Only my submissions may be recorded that this petition is not maintainable as because it is filed by defendant number 1, 2, 3 being private defendant.
That is your submission. On that, I will give some finding.
Yes.
Whether
Lordship has to set aside this order, then send it back for fresh disposal for further proceeding in the...
Yes, I will say I'm setting aside this order,
Lordship.
but for some other reasons, which I will mention in the
Lordship.
orders.
Then Lordship, defendant number 6 will appear and again he will file an application on the
Yes.
same grounds, Lordship.
Yes, there is
He
no.
may not pointed out this, Lordship. It is his liberty. He can file or he may not file, Lordship. So if your Lordship...
Okay, I will not point out. I will not point
If
out.
your Lordship record that in the order itself, then defendant number 6 will appear and again he will file, Lordship.
He may otherwise also appear and file.
Lordship, he will appear. He may file, he may not file. But if we reflect it in the order, Lordship,
Okay.
he will take the benefit of the order, Lordship.
Yeah, I will consider
The
that.
only thing is, so far order 7 rule 11D is concerned, regarding a point of law, there is no bar,
That I will also address.
Lordship, only numbering of title seat is 19/2023. Your Lordship has recorded as 9/2023.
19/2023.
The first part of order.
Okay.
And
Okay, remaining part I will dictate in chamber. I will dispose of the matter. Give your judgments to me.
I have handed
Malad, may I
over,
also take note of, Malad, they haven't filed any objection against my petition.
and Lordship has recorded that the suit was fixed on 24/3, but the learned trial court has taken up the matter on 27/2 on a petition filed by defendant number 123 on the date itself. They have filed the petition on 16/2, Lordship. And then learned trial court has taken it for consideration on 27/2. The petition itself
Off
says,
date, on the off dates.
yes, Lordship.
Which was not
It
fixed
is
for.
not filed on the same date when it was considered.
Okay.
That may be a wrong submission from me, Lordship. Otherwise, the petition itself says that 16/2/2023, the corner, the date is there after the petition number.
And order was passed on 24 to
27/2. 27/2.
December.
So when the petition was filed on a off date, then the court taken a date to be fixed for consideration of that petition, Lordship.
Yes, this I will take into consideration. Judgment to law in chamber.
I have given two judgments, Lordship. Obliged, Lordship.
None of them. In chamber of the officer.
May I please your lordship? I beg to mention item number 26. I have taken consent of the other side. Kindly adjourn the matter for the day.
Heard Miss, what is your name?
Espal, appearing on behalf of Mr. S. Datta.
Espal, learned counsel for the appellant. Who also heard Mr. M. Khan. She's seeking adjournment. Learned counsel for the appellant seeks prayed for adjournment on the ground of personal difficulty of the conducting counsel for the appellant. The prayer is allowed. Let this matter be listed on 26th of March.
Highly objectionable.
Matrimonial. What is this matter?
Milord, here is a case, Milord. Here, the wife, Milord, she was living in adultery since long.
Your husband?
I'm the husband. Now, Milord, she started living with some other person. It is on record. It's the admitted facts. She had filed a DV case against me.
Item number 28, I'm for the applicant. He wants because he filed an application as your lordship recollect for early hearing. He wants it to be fixed on a date.
You matters, huh? What is the item number?
Item number 28.
my lord.
When you want? First week of.
Day after tomorrow, my lord.
He wants it on Saturday. Your lordship. Any other date, your lordship may feel convenient. Except for 23rd, I will be out of.
Coming Saturday.
Any other date?
Coming Saturday, 21st, he has given money.
5th of March.
Bye.
Is it okay?
24th, my lord.
24th March.
Lord, I will be, can it be, because there is a family marriage on 4th. I may not be on 5th.
24, 26, 24,
No.
24,
March or June.
February, 24th and 26th. Because my lord, there is an order for early hearing.
20, no, that is,
Yes.
I am not disputing.
24 or 26, my lord, if possible.
If he wants that it be on 26th, that is a Thursday, if it is convenient for.
26. Kimana se. No, it may not be possible.
Then-
Because we will, if we list it on 24th,
Then on,
Again at 4:30, we'll be making such
then
prayer.
10th of March, your lordship,
10th,
Tuesday, I think that would be.
Fifth of March.
Fifth, I will be there. There is a family marriage.
10th of March. Heard Mr.
Fifth of
A.
March.
Vishwas,
The way
learned
to-
counsel
No, no, मैं कहाँ रहूँगा?
for the appellant. Also heard Mr. A. N. Alam, learned counsel for the respondent. Due to paucity of time, this matter could not be taken up for hearing. Let this matter be listed on, yes,
10th, your lordship.
10th of March.
Yes.
In the top of the list, my lord, if possible.